forgive my forgive the fact that I don't have a jacket. I'm in home quarantine at the moment, so I'm doing this in my basement room to keep away from the kids. I declare open this public hearing of the Parliamentary Joint Committee on Law Enforcement for its inquiry into law enforcement capabilities in relation to child exploitation. Committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web and in Parliament House. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. It's important that witnesses give the committee notice if they intend to give evidence in camera so we can switch to that mode. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as an act of contempt by the Senate. It's also an act of contempt to give false or misleading evidence to the committee. A witness called to answer a question for the first time should state their full name. Oh, that's right, I'll actually do that. Okay, that's the formalities done. Good and proper. I would now like to welcome our first witnesses for today, a representative of the Uniting Church Synod of Victoria and Tasmania. Mark, you've got myself as the chair, you've got Deputy Chair Dr. Ali on the line, Pat Conahan, and Senator McLaughlin. Thank you for coming to address the committee today. We have a copy of your submission, obviously, which we have read thoroughly, but we're keen to ask some questions, but we've got 45 minutes with you. For the record, would you please state your full name and the capacity in which you appear at this hearing?
Dr. Mark Zernczak. I'm the Senior Social Justice Advocate for the Uniting Church in Victoria and Tasmania.
Fantastic. Perfect. No, that's all that's required. Well, as I said, we have read your submission, so we're not after a repeat of that, but mate, you certainly have 5 minutes if you'd like to make an opening statement to the committee about what you're keen to explore and your takeaways from the submission, and then we'll leap into some questions.
Thank you very much, and thanks for the opportunity to appear before the committee. So without rehashing the entire submission, I'll stick to probably making some high-level points. So one is that the sheer volume of child sexual abuse and child exploitation online, the volume is so large that the police strategy of simply arrest and prosecution is inadequate, and I think law enforcement agencies have repeatedly said that. So our focus has been on the need to look at measures that prevent, deter and disrupt this activity. So to get the volume of offending down, to also prevent people entering that trajectory of getting into child sexual abuse, and to also provide a safer online environment for children in the first place so that there is less potential for them to be targeted. So in that regard, the work by the E-Safety Commissioner on safety by design with regard to technology is a really valuable contribution that's being made in this space. I probably would want to emphasise one of our key measures that we have put forward is that technology companies move to identify users. Now, I think, unfortunately, the current debate in public around this is exceedingly disappointing. It's either you have a completely public identity or you have a completely anonymous identity. Now, obviously, you can have an anonymous identity that's outward facing, so people don't necessarily need to know who you are, but the platform provider in all cases should know who you are. So the test here is that the platform provider actually knows. So if you actually misuse your profile, your account, then law enforcement is able to easily identify you and not waste a lot of time doing that. And to highlight the damage that can be done, I mean, the recent case of Aladdin Linamin from Sarawak, Malaysia. So he was recently sentenced to 48 years in prison, but he started posting child sexual abuse material online in 2007. And because of his ability to have an online anonymous identity, it was not until this year that law enforcement agencies globally were finally able to identify him. In that period, he was able to post approximately 10,000 images and videos of child sexual abuse. And the Australian law enforcement agencies have identified 34 of the children who were the victims of his abuse. But there may have been more beyond those that have been identified. So that is the consequence of allowing people to have these completely anonymous identities, rather than a situation where the platform knows who you are, even if publicly you can have an anonymous identity that's publicly facing, which is needed for some other reasons as well. The other thing that I probably would want to emphasise here is the need, a really no-brainer in here is the complaints mechanism that we've suggested. The research by the Canadian Centre for Child Protection indicates quite clearly that there is a need for online platforms to lift their game in the way they provide complaints mechanisms, particularly for survivors to be able to report material that is present on their platforms, and also help identify offenders who are using those platforms. The one that we didn't cover that I should make mention of is pop-up messages. Now, I know the Australian Institute of Criminology has just released a paper that has talked about pop-up messages, and there is work done down at the University of Queensland looking at pop-up messages. They are used in other jurisdictions, so the notion, particularly you can tie it currently to where ISPs are required to give people a warning message if they're trying to access a site that's on the Interpol worst of the worst list, and the pop-up message either warns a person that they're trying to access illegal material, and also in some jurisdictions there is the suggestion that you can offer the person a referral, that if they're having thoughts about child sex abuse, that there are places they can go to get assistance to help them overcome those thoughts and that behaviour. So they are things people are experimenting with. I know Facebook announced at the start of 2021, they announced they were also experimenting with pop-up messages on their platform as well. Well, look, the final thing I'll just make point of, I do think at times in this space, there's often, I have a significant disappointment with sections of the human rights community who appear to champion the right of privacy over all other human rights. If you read their submissions often in this space around online regulation, they will not acknowledge that the abuse of children in the online space is a human rights abuse. I just find that truly bizarre. And even when it comes to the right of privacy, which they claim to be upholding, they don't seem to give any acknowledgement to the violation of the right to privacy of survivors when images of their abuse is being posted online, and when platforms are not taking steps to detect and remove that material. So there is, there is more than just the right to privacy of potential offenders. There is also the right to privacy of their victims and the survivors of child sexual abuse. I'll open it up for questions at that point.
Thanks very much, Doctor. Much appreciated. And I just also make the point that Senator Alex Antic has joined us as well on the teleconference. So thanks very much, Alex. So, Doctor, there are two senators on the line. They can hear you and they'll be able to ask questions. You just can't see them on the video conference. Look, I might take the running if that's all right initially as the chair, and a couple of questions. So, first of all, thank you very much for the Church's interest. It's obviously, I can tell from your submission, it's very genuine and very practical in its nature, and well researched too. Just to pick up on your point about providers having to know the identities of users. Obviously, we're going that way, or keen to go that way with our anti-trolling measures that we've recently announced, and you alluded to that debate. I can see how that would have context in the example that you use, where somebody is using a social media service to access CAM, but the reality is I would have thought that most of them aren't doing it as openly as that. Most of them would be in encrypted forums or on the dark web or other the likes. So where do you see that need to know who a user is relates only to social media accounts, or is it more broad than that?
Oh, look, I would argue it's across all platforms. So it's the very issue of, and I met the recent documentary that was released, Children in the Pictures, and I'm sure the police witnesses you'll have before you will testify more to this, but it was quite clear, we've known this for quite a while, that police will break into a network and then they have to spend a long time trying to figure out who the actual real people behind the handles that are being used in those child sexual abuse networks are. So now if it was, if it was a matter that they could just go to the provider and obtain that information, here's the handle that's being used, who's the real person behind that, clearly that would speed up detection of offenders and prevent ongoing child sexual abuse. It's really disturbing that delay in being able to identify an offender means that children can be subjected to ongoing sexual abuse while the offender is being identified.
So it'd be a matter of ISPs knowing who each user is, essentially, as on top of on top of tech platforms.
Well, it would be all the technology companies that effectively, when I open an account of any sort, when I subscribe, I have to provide the natural identity. Now, look, none of those systems are going to be absolutely perfect. I mean, I'm not, we're not naive about that. If a really dedicated offender might still go to enormous lengths to conceal and use a false identity, look, that's still. But you're going to make it harder, and the more you can do, this is the point. This is the issue of disruption. The harder you make it for people, the more you're going to deter them from doing that, the more you're going to remove any perceived sense of anonymity they have, that increases their sense that I can get away with this.
No, look, and that's a good point, and I have sympathy for your point that to a certain extent, penalties can only go so far as a deterrent, and once you have stringent penalties in place, which I think we do, then it comes down to their likelihood of being caught and them being convinced that they will be caught. A number of your recommendations relate to, for example, penalties against tech providers who don't comply with law enforcement, which, nothing against that in principle. We already have, and the committee's done recent work on the AVM Act, which has a similar framework. And I'm wondering, in putting together its recommendations, how familiar was the church with things like the AVM Act and the new SLADE powers that we've given law enforcement?
Yeah, look, absolutely, and I think the Parliament has been moving in the right direction on this. I think what we were highlighting, though, just wanting to make sure that in the legislation, like our suggestions to the committee really is to explore the degree to which the current legislative framework would allow individuals to be prosecuted for refusing to comply rather than the company. Our fear in this is that if it's just the company that gets hit with a penalty, a financial penalty, for example, they might still think it's worth their while to not comply with a request. Whereas if it's the individuals inside the company who are making that decision to not comply with a lawful request under the legislation, I think you'll find that will motivate compliance far more. In part, again, evidence on this. And look, I think the complexity around this, I don't want to paint the big tech companies. Many of them, they're not completely villains and they're not completely heroes. They have really mixed behaviour in all sorts of ways. And I don't doubt some of the genuineness of the measures they are taking to address this. But when I look at the recent expose, for example, in the Wall Street Journal, where you've had insiders and you've had leaked documents from inside Facebook showing enormous delays in basically complying with basic law, allowing a Mexican drug cartel to recruit hitmen and pay them over their platform and promote their work for 5 months before taking it down. It suggests, at times there are people inside the organisation who are not highly motivated towards protecting human rights. So I think, a clear signal to sort of say, well, individuals can be held to account would certainly help encourage greater compliance among those who might be resistive.
That kind of deterrent legislation, who do you think it should be holding to account? You talk about individuals. Are these, you think, content managers or ultimately CEOs or board chairmen, or who is the individual in your view who should be receiving penalties for not acting reasonably enough?
I think what we said was the decision maker. So, I mean, I'd be reluctant to see, for example, a contracted Filipino content manager, in a subcontracting firm being held to account for following strict instructions about what they should be doing. That would seem inappropriate. The person who needs to be held to account is ultimately the person who's setting the instructions to those employees. So I think it's at the level of who's making that decision inside the organisation who gets held to account. And that would also then put the CEO and the board potentially on notice, because ultimately if they're not sending clear signals to their staff about what the acceptable standard is and the need to comply with the law, then ultimately it will come back to them. If they're sending a signal that refusal to work with law enforcement or obstruct law enforcement or hinder it, isn't acceptable behaviour, then ultimately they would be the ones held to account as well.
Yeah. So, I mean, we're going to hear evidence later on today from Victoria Police, and they noted in their submissions that their request to say Facebook can take anywhere from 6 months to 2 years. So, in those kind of situations, you would like to see an enforcement regime where the CEO and the board of Facebook are held accountable for those delays.
If they're the ones creating the delay, I mean, if they've sent a clear instruction that, you know, there should be, and it's a middle manager who's not complying with the company's behaviour, then you know, ultimately that middle manager be the one. But you'd kind of think that if it was only a middle manager breaking instructions, that there'd be internal discipline by the company to hold them to account as well. So it does seem to suggest resistance of that nature goes further up the chain in terms of who's setting the policies that's allowing that kind of lack of cooperation to occur.
Yeah, you mentioned this idea of content managers in the Philippines, and I picked that up in your submission too, about this concern that you have of content managers in third party countries who might be in their efforts to take down material destroying evidence that law enforcement needs. You mentioned the documentary as one example, but I mean, beyond that, have you collected evidence of other examples? How widespread do you think this is? Because as an issue, it strikes interest to the committee, and I think we need to explore it further. I'd like to know how far you've kind of taken it yourself.
Look, we did, so the private investigator we used has mapped some of the content management firms in the Philippines, and they already found not so much on evidence destruction, but disturbing about the way that some of them market themselves about, you know, we offer the cheapest possible labour for content management that you'll find anywhere on the globe. That's not a great sign about how they treat their employees or expectations. We actually had set aside budget to investigate, and then unfortunately COVID hit us. So we actually have an on-the-ground investigator lined up, ready to go. And as soon as restrictions start easing, we will be trying to do some on-the-ground investigation to further verify the kind of problems. Because also that documentary, The Cleaners, that I referred to, didn't identify which providers were accessing the content firms where you had the content manager basically alleging that they had destroyed child sexual abuse material without preservation. Now, we did take this up with, for example, Facebook, and Facebook gave us an absolute guarantee that their company-wide policy and practice is to preserve evidence and report it to law enforcement agencies or report it to the National Centre for Missing and Exploited Children in the US. And we have no evidence to the contrary that that's not what they're doing. So it could be other providers that are using the content managers where evidence is being destroyed. So we do plan to look at this further, but we also thought it was worth raising to the committee, because in this case, it's not just, you know, coming from a church background, you know, where the church has failed terribly in dealing with child sexual abuse. I mean, often the allegations were verbal allegations. In this case, you've actually got the hard evidence being presented. You're actually seeing the abuse taking place. You know, so to destroy that evidence is far more egregious than, you know, to my mind, is more egregious than someone who simply dismisses a complaint being made. Not that dismissing a complaint is in any way excusable either. That's completely unacceptable behaviour as well.
But you have undertaken some efforts to map particular companies, did you say? Is that, and map providers?
Yeah, we have mapped content management companies in the Philippines that we wish to investigate, and we will look to do that.
Right. So you're not sure whether they are in fact undertaking this practice, but you've taken some effort to awareness to see them. Is that something that you can provide to the committee, even if it was on a confidential basis, that we would keep confidential?
Look, we can provide you with a list of content management companies that are on our, you know, potentially we'll look to investigate. Happy to do that. Probably the only issue, though, we haven't got to the chance to do the investigation yet because COVID stopped us from getting there.
And you're not trying to infer guilt by just having them on that list. I understand
Correct.
that.
Exactly.
But look, the list would be helpful just so the committee can understand the extent to which these companies are used, and so we can undertake some of our more due diligence.
More than happy to provide that.
Look, finally, before I hand over to the Deputy Chair, because I'm exhausting my time pretty quickly, is it's a topic that has been raised by a number of submitters. So we're going to be talking about it throughout the day. But I'd like to just get your views on the record, and that is the idea of harm minimization strategies that could be put in place, whether these would be around rehabilitation or similar to drug programs where offenders or potential offenders would hear from victims about the damage that it does. I mean, can I get your view on how you think that would work? I mean, look, I'll be upfront with you and say that I probably have some concerns that we would have to be careful in such programs not to destigmatize the offending too much within the community, because it deserves to be stigmatized, quite rightly. But I'm willing to have the discussion with people about how they think those programs would work.
Look, I haven't kept up entirely with the offender literature in recent years, so we did look at this a while back, and it did seem at that stage it was quite a debated area. So there was one side of the literature that said there are offenders who are only are non-contact offenders. So there's a notion that there are people who simply view material or purchase material online, and they themselves are not contact offenders. So they commit no physical offence against children. And the argument has been, sometimes when those people get sent, for example, into a treatment course, once they're prosecuted and incarcerated and they're put in with contact offenders, they have a similar reaction to contact offenders that any other member of the public would. And they somehow see themselves as different to contact offenders. They somehow, in their mind, justify this distorted thinking. I didn't do anything wrong. I was just looking at pictures. I didn't actually harm the children. There is another side of that debate that actually says those people don't exist. There aren't non-contact offenders, or if they do exist, they're a very, very small group. And in fact, many of those who get classified as non-contact offenders are simply contact offenders who haven't been detected for their contact offences. Certainly, I've heard that view from law enforcement quite strongly. So there will be law enforcement agencies who will very strongly say offenders.
Yeah, look, we certainly understand both. We certainly understand both sides of the debate. What I'm trying to get at is, where would the church fall, or you can offer your own view or whatever you want to do. But do you have a view one way or another?
I think if there is an identifiable group of non-contact offenders and there are programs that would help rehabilitate them, we would certainly support those. I think some of the challenges would be, do they, one of the things we've talked about with people is, do they occur in sufficient numbers that you could justify a program that would just target them? Because otherwise, an offender who's a contact offender who's also engaged in offences online probably, will access standard rehabilitation programs that are available for contact offenders more generally. So I think that's probably the question: is does that group exist, and to the extent they exist, can it be justified to have a program that specifically targets them? There is literature that seems to suggest for programs targeting genuine non-contact offenders are quite effective at reducing offending and recidivism.
Okay. Deputy Chair, I'll hand over to you.
Thank you, Chair, and thank you, Dr. Zirnsak, for appearing today and for your submission. I wanted to start with the Abhorrent Violent Materials Act, which this committee recently reviewed, and some of the evidence that we heard in the review of that Act, specifically that the majority, around 90% of material that's taken down, relates to torture and rape, and specifically to child abuse material. And I wonder if you could please comment on the possible effectiveness, if you like, of the Abhorrent Violent Materials Act, which compels social media platforms to remove AVM, and its effectiveness in addressing CAM.
Look, I think that kind of legislation we fully support and do see massive utility for it. I couldn't comment on, I think a proper evaluation would need to be done to measure how well has that performed in addressing child sexual abuse material. I mean, but as our submission goes into, and that is based on the evidence of the Canadian Child Protection Centre for Child Protection, that you have content hosts who will resist takedown notices and dispute the need to remove child sexual abuse material or material related to child sexual abuse, or will engage in massive delay in removing that material. So obviously you've got some providers who will are very on board and very supportive and will move very quickly to remove material. But as per our submission, there are clearly far too many content hosts who will either delay, not see it as a priority, or in some cases actively dispute removal of material. And that's why a law that requires that removal is really necessary to level the playing field, to make sure that there is a minimum standard for removal.
So the AVM does require them to remove, and if they don't comply or if they're considered reckless, there's pretty high penalties for it. And one of the things that we heard in that evidence was that the E-Safety Commissioner has never had to issue a notice to any of the big social media companies there. And then we heard other evidence that it's usually the smaller service providers who lack capacity to monitor, to remove content, to do all of the things that the larger ones have. Is that also something that you found, that it's predominantly the smaller service providers, or are we talking here also about large service providers, you know, your big social media providers?
I haven't heard it about some of the large, you know, the very large service providers. I think the reputational risk in refusing to remove child sexual abuse material, reputational risk alone, I think would compel them to not be in that space of resisting. So I do think it's correct to say it will be the smaller providers. I would accept that for some of them it probably is a capacity issue around the speed at which they remove, but clearly, as I indicate, the Canadian Centre for Child Protection has demonstrated that there are providers who actively dispute. So it's an ideological resistance to cooperating in that space. I mean, there was delay, though. I think we highlight there is some evidence there was delay with WhatsApp previously around a group. So, you know, that said, because again, within the large corporations where they've absorbed other companies, the culture across such a large corporation can vary. So my understanding would be, for example, the culture in WhatsApp has been one more towards secrecy and providing secrecy to their users more than Meta now as the large company would have as their across the board policy. So I would accept, you know, there's variety within that space. But again, it highlights the necessity for that. And look, our view would ultimately be if a company is incapable of meeting such a basic requirement to provide a safe platform and remove apparent material, then I've got a question: should they be in this business at all? Like, you know, I don't think we should be catering our laws or sacrificing the rights of victims and survivors for the benefit of people who seem incapable of meeting basic requirements. In the same way that we wouldn't allow someone to establish a financial institution if they couldn't meet basic requirements of running that financial institution appropriately with the appropriate probity and safeguards over the way they operate. So I think the same applies to technology platform providers.
And following on from that, on page 13 of your submission, you state that in 2019, the Internet Watch Foundation reported that child sexual abuse material was hosted on the following platforms. And I found this actually quite interesting, that 84% of material is on an image host. By far the majority, because then the next one after that is a cyber locker at 6%, banner sites, websites, forums, video channels, image boards, search providers, and social networking. And then you go on to give the example of Facebook, WhatsApp. So I wanted to ask you about platforms like, for example, Snapchat, or these ones where you have small groups of people who can share images with each other, and whether whether you're seeing an increase there. Is that being used to distribute and share child abuse material?
Look, I think a couple of things to say about that data. I mean, the Internet Watch Foundation data is about material that is more static material. And also the other thing to remember about that is it also represents the sample of detected material. So there is a risk in this that what it's indicating is material is more easily detected on an image host than on some other platforms. So, you know, potentially if a platform is very good at providing secrecy, then obviously detection rates are going to be much lower. I'd treat, I mean, we presented the data, but there are a couple of cautions around the interpretation of that data.
Always cautions around data.
And secondly, so then you've got the difference also between hosting of material and hosting of images versus platforms that allow networks of people to actually interact with each other. And I think the Virtual Global Task Force has indicated they have seen an increase in people networking on a variety of platforms. To actually, now most of those I think they have indicated are in the dark web, but I don't think exclusively in that space either.
I just had one more question, if I may. So in the material that we've been given to kind of read on this, in 2020, the Child Protection Triage Unit received 21,000 reports of online child sexual exploitation, and the AFP charged a total of 191 people with 1,847 alleged child abuse related in 2020. There's a stark difference in the volume of material that's out there compared to the number of the number of people who are held to account and the volume of material that applies to. In your opinion, is that largely because of the gaps in legislation that you have recommended in your submission? And here I predominantly refer to making it an unambiguous offence to not or to hide the identity of an offender.
Look, I think there is in part the current system is stacked against law enforcement, and investigations end up being slowed down by that inability to identify offenders. And this is also why we recommend that the Parliament, make amendment to the degree that's necessary to the international production orders. But the notion that simply to get data to identify someone can take 6 to 12 months through a mutual legal assistance request across a border, that's just an unacceptable regime as currently exists. So there is a slowness. I mean, our understanding from law enforcement is they have far many more cases than they can possibly deal with. On the other side, I probably should say though, as Facebook revealed with they put out some data at the start of this year where they said they'd worked with the National Centre for Missing and Exploited Children. They looked at all the material they'd reported to the National Centre for Missing and Exploited Children in October and November 2020, and they found that 90% of it was material that had previously been identified, and that half that material, half those complaints that they reported related just to 6 pieces of material. So with that 20,000 complaints, what would be interesting to explore is how many of those complaints were duplicates of the same material. So how many people, are they getting multiple complaints? To what degree is it multiple complaints of the same material? So what would be more interesting is what were the unique complaints that identified individual new material that law enforcement was previously unaware of, and then look at what's the gap between that new identification versus what law enforcement have been actually able to tackle. But again, you're right to raise the question. I think absolutely the more that this committee can make recommendations that speed up the ability of law enforcement to deal with cases, the more cases they can deal with. But as I said at the beginning, I think even if you did all of that, even if that system was perfect, the sheer volume of offending is still at a level that investigation, arrest and prosecution in itself is not going to be enough. Law enforcement itself say that, and therefore we need more measures that prevent and deter right at the beginning. So we're reducing the volume of offending by deterring people from getting into this in the first place, and that leaves law enforcement to go after the higher end offenders, the worst offenders in this space who won't be deterred or won't be swayed away from this behaviour.
Okay, I have a few questions around deterrence, but I'll stop there and pass on. Thank you, Chair.
That's all right, Deputy Chair. Thanks for keeping us on track. That's very kind of you. We'll try and come back to you if we have the time at the end. Pat, you want to go next, mate?
Thanks very much, Chair, and hopefully, Deputy Chair, I'm going to follow on in terms of deterrence. Mr. Zernzak, thank you for your report. It's very detailed, and obviously you and the Uniting Church have a major concern about child protection, which is good. I just want to talk to you. You've dived deep in terms of the challenge of general deterrence in the online world at 5.1 of your report. In the legal world, whether it's states or territory or the Commonwealth, deterrence is broken down into both general deterrence and specific deterrence. And you're nodding, so I see that you understand that there's a difference. General deterrence, obviously, is to the general public, and penalties are imposed or consideration is given to general deterrence to prevent people or deter people from committing these offences. So that's the first issue. The report seems to conflate both general deterrence and specific deterrence, where someone is being sentenced and specifically punished as a specific deterrence to the individual in terms of jail sentences and ongoing punishment once they're ultimately released. Is there a reason that you didn't look at specific deterrence when you were talking about whether or not this rehabilitation program, which I don't support, is there a reason you didn't separate the two?
So what our focus is, as I said, we're looking to get the volume of offending down in the first place. So our understanding based on our look at the research would be the problem is the number of offenders. So if the bulk of the problem was the same people offending over and over and over again, then you would argue the solution is tougher penalties targeting those individuals. If the problem is there are large numbers of people engaging in this behaviour, and most of them think they can get away with it as the reason they're doing it, simply the smallish number who are getting caught being punished more harshly, our understanding of the criminological literature is that doesn't provide a general deterrence to that population who would otherwise offend and think they can get away with it. So what we're trying to say, the bigger problem you've got in this space is how do we create an environment where people think if I engage in this behaviour, I will get caught. And like I'm postulating to you that if I think I'm going to get caught, I'm probably what's probably going to be more important in my mind if I'm engaging in this offending behaviour is not will I get 5 years or 10 years in prison, but will I get caught in the first place? And if I get caught, will I be successfully prosecuted? I think that's what the criminological literature suggests, that is the greater deterrent effect. And that's why we talk about general deterrence, because it's getting that volume down as opposed to, and then the question you've got is, if you give someone a 5-year jail term or a 10-year jail term or a 15-year jail term, to what degree does that deter that individual from reoffending? So what's the severity of that penalty? To what degree does that affect recidivism for this particular crime type? And our understanding was that increased severity doesn't do much for recidivism, even among those individuals who are subjected to those sanctions. Now, look, the Australian Institute of Criminology might have further views on this. They're the people we have spoken to in the past about these kind of issues around what works in the recidivism area in this space. And having read the literature previously, my understanding that I walked away with out of that was that simply harsher penalties beyond those that we've already got in place probably isn't going to do a lot to reduce recidivism further.
I don't know if you've heard the term paradox of dispossession. Those who have little to lose don't really care. They will commit an offence anyway because they've got nothing to lose. So let's look at the people who have a lot to lose, and they're generally the ones on the board of the platforms, the service providers, and look at the specific deterrence to them. Have you done any research or a deep dive in terms of what international, because they're all overseas, they're not based here. what international agreements would apply, whether they're in treaties, in terms of penalties to the executives for not complying with, for example, if we enacted legislation and had a treaty with, let's say, the United States that looked at the executives of these platforms to say, if you don't act, then we're coming for you, and here's your specific deterrence in terms of financial penalty, restrictions to your online platform, or even jail sentences.
Look, I would suggest we already have that in other forms of cross-border crime. I mean, you know, if a company here, you know, a multinational company that has an Australian branch, and the Australian branch pays a bribe in an international bribery situation, you know, you would hold the Australian management of that subsidiary to account. And I can't see why, you know, these companies have subsidiaries based here in Australia. I mean, you would ultimately, you know, my guess would be you would hold the management of the Australian subsidiary to account for their failure to comply with Australian law. That would be my immediate response to that. But look, obviously, that might be something to take up with the Australian Federal Police, and
Yep.
you know, in terms of how practical that would be in terms of doing that. But I don't think it's uniquely different. I mean, similarly, you know, we've got large multinational banks that have branches, subsidiaries here in Australia. We hold the executives in those institutions to account who are based here in Australia. So it's not a unique situation to this space.
Okay, look, I'm conscious of time as well. Thank you very much, Mr. Zernzak, and thank you, Chair.
Thank you, Pat. Deputy Chair, are you still there? Did you want to resume your line of questioning for the last 2 minutes, or you're okay? She mightn't be there, so I'll ask a couple of questions in the last few minutes that we have. The recommendation about the requirement for those under 13 to not get on without parental consent. I just wanted to get your view on how you think the public would respond to that idea, because obviously it would involve a parent having to give some form of ID or something like that to a service provider. But I suppose we're moving down that path with the anti-trolling legislation, and also, you know, how much attention we should pay to ensuring that under 13s aren't on this platform, and pushing platform providers into that avenue versus pushing them to provide more parental controls on an ongoing basis and building that into their platform. So in fact, when people do slip through, as inevitably they will, that there's some ongoing monitoring that parents can do.
Yeah, look, I think don't have strong views one way or another on this. I suspect the public might react more negatively to a view if the Parliament was to simply say, if you're below 13, you can't be on a social media platform at all. I suspect that might create more pushback than the suggestion that parental approval is needed for someone 13 or below to be on the platform. And that was aligned obviously to existing US legislation anyway, which isn't isn't enforced. Right. So I think the issue, as we raise in there, is the psychological evidence. My understanding of child development evidence is below, you know, children 8 to 12 particularly are good at using the technology, but don't understand the consequences and the trouble they can get into. I guess I'm also swayed by having attended the eSafety Commissioners Conference and listening to people talk about their experience of having their kids on platforms that are supposed to be, you know, child-only platforms, and kind of feedback was, you know, child sex predators are prolific in those platforms because of the lack of identity that's required. So you're not creating a child-safe space if you sort of declare it as child-safe space, but effectively anyone who can then pose as a child and enter that space. In fact, you're making it a magnet or an attraction for those who wish to target children. So I think that, you know, that's the kind of thing we're trying to respond to with that recommendation. If the committee has a better way to deal with it, you know, we're open to sort of saying, are there better solutions to this particular problem? But that's the problem we're trying to address, particularly is the the current one where we don't identify people, and the fact that children of below that age are at risk of knowing how to use the technology but not really understanding the consequences of what they might get into or how they might be targeted.
Yeah, yeah. No, look, I'm with you there. All right, look, thank you very much. I appreciate you taking the time to give us evidence today. I do like to keep us on time, but that was very beneficial, 45 minutes. So thank you very much. And again, our thanks for the very detailed submission and the passionate way that you and the church are taking this up. Much appreciated.
Thank you for the opportunity. Really appreciate it.
Okay, Sean, I can see Anne Louise there. So, how's it going? Sean, are you happy for us to keep going? Oh, you're on mute, are you, buddy?
Good to go.
Excellent. Okay. And Louise, I did a bit of formalities at the start, so I won't repeat that except to say, obviously, this is a public hearing, so be aware of that. Everything that you say is being broadcast on the web. If you want to switch to an in-camera or confidential mode, please just give us the heads up before you give that evidence so that we can turn the broadcasting off. On the line, you have myself, obviously, as the chair. You have Deputy Chair, Dr. Anne Ali, who's there from Western Australia. You have Pat Conahan, who you can't see at the moment, but he's there. And you have two on the teleconference who you can't see, but can ask you questions and can hear you. And that's Senator McLaughlin and Senator Antic. So thank you very much. What I might do is get you to state your name and the position and your position that you're appearing for the record for us.
I'm Anne-Louise Brown, and I'm the Director of Corporate Affairs and Policy at the Cybersecurity Cooperative Research Centre.
Fantastic, fantastic. And look, we all have your submission. We've read it thoroughly. Myself particularly thoroughly because I'm stuck in home quarantine and there's not much else to do. So obviously we're not looking for you to rehash the entire submission, but and we're very keen to ask you questions, but certainly you are welcome to give a 5-minute opening statement if there's particular things that you want to highlight for the committee's benefit.
Thanks, Chair, and I'll be brief. But I thank the committee for the opportunity to contribute to what is a very important inquiry. It is particularly timely given the exponential increase in the production and distribution of child sexual abuse material, which has been further fueled by the COVID-19 pandemic. It is essential Australia remains a prosperous digital economy while also protecting the most vulnerable members of our community, our children, from online sexual exploitation. The Cybersecurity Cooperative Research Centre is dedicated to fostering the next generation of Australian cybersecurity talent, developing innovative projects to develop our nation's cybersecurity capabilities. We build effective collaborations between industry, government and researchers, creating real-world solutions for pressing cyber-related problems. Sexual offences against children are among the most abhorrent crimes in our society, whether committed online or offline. Before the advent of the internet, these crimes generally occurred where an offender could access child victims. However, the proliferation of the internet and encrypted messaging applications have proven a boon for child sexual offending and the production and distribution of child sex abuse material. While there are perceptions that victims of these crimes are overwhelmingly located in overseas jurisdictions, there are also many Australian children affected. And the methods used by their abusers have grown ever more sophisticated, with encrypted applications and the dark web providing a cloak of invisibility to their offending. Accessing and viewing child sexual abuse material is not a victimless crime, as many perpetrators believe. It has devastating and lifelong impacts on the children that are abused, with abuse images living on unfettered and uncensored in a world of clandestine online child sexual abuse material. Given the scale of child sexual abuse material and the devastating impacts it has on the millions of exploited victims around the world every year, it is necessary that law enforcement has appropriate powers to disrupt, detect and bring offenders to justice. To this end, the Slade Bill, which was passed by the Parliament in August, is a game changer in tackling the scourge of child abuse material. However, this is a shared responsibility and there is a clear role for technology providers to play in helping law enforcement combat child sexual abuse material through monitoring, removal and reporting of such content. Finally, the CRC submits that an absolute right to privacy can never exist and there must always be exceptions, especially when it comes to maintaining the common good. This is a principle recognised in the International Convention of Civil and Political Rights, which makes explicit exceptions where privacy can be overridden, including for the protection of national security, public order, or of public health and morals. The CRC contends that while privacy is valuable, it must have limitations, and these limitations must correlate with the social contract all members of the community enter into, upon which modern democracies like Australia's are built. This is a concept that can no longer be applied just to the physical world. In 2021, it must also incorporate unacceptable behaviour that occurs in the digital domain. Thank you.
Great, thank you very much. And look, obviously, I might kick off the questioning if that's all right, as is the chair's prerogative. I'm a big fan of what your organisation does. You know, we've engaged on other issues previously, so congratulations and thank you very much for the submission. And certainly your opening statement is right along the lines of the committee's thinking. Given the CSC's really significant knowledge and technical know-how and the like, I wanted to throw some of the more challenging aspects that we face to you, if that's all right. You mentioned the slide bill, and I'm pleased you singled that out because I'm with you. I think it's a good step forward, but you indicated challenges, and one of those challenges still outstanding is encryption. We're going to be talking to Facebook tomorrow, but you've raised encryption in your submission. So some other submissions have raised that there is, still some things that, some technical things that providers can do, even if they want to maintain their encryption, they can still check messages and the like. And I wanted to get your view on, I know it's a really tough challenge. That's why I warned you that in advance. But where do we go to start solving this encryption issue?
Okay, so I'll just start by saying I'm not a technical expert, but I do have a high level understanding of what this means. And so, I know within some of the submissions from tech companies, they do note that there are ways that they can use metadata to, use encrypted data to track behavior, for example. So I've done a bit of reading on this. And so the Google submission in particular raises that, they can use metadata and behavioral analytics to help locate and stop child exploitation material online. The problem with this is that it really does, in my understanding, rely on behavioral aspects. So the metadata can basically correlate patterns. It's like pattern theory. So it will find the patterns in particular behaviour and the anomalies within that behaviour and pinpoint that, which is fantastic until the criminals that are perpetrating this kind of activity realise that they are being, tracked or traced via this form of behavioural analysis, at which point they will change their behaviour. That's the nature of this kind of crime, because it's to remain undetected. So while encryption provides that safety, and there are the sort of the behavioural analytics that can be used to detect it, it's only a matter of time before these criminals pivot again to something new, and that again just they go dark again. So the other problem being with encryption. Sorry.
No, you go.
I was just going to say the other problem being that despite that, they can't actually see what's in the message either. So while they might have an inkling as to the fact that it's child sexual exploitation material, there's no way of telling.
Mm-hmm. So should it be an expectation that if these platforms are going to set encryption as a default, that they are expected to do the flip side of the coin, and that is to at least make an effort to monitor where they can the behavioural aspects of it? Is that something that you'd be looking for government to regulate or to legislate, or are there other jurisdictions that are doing something like that?
Look, I think that it's, it's an admirable aim. Um, it, the tech companies will push back against
Yes.
that. Obviously, we
We're
know
getting kind
that
of used to that.
yeah,
Yeah.
that Facebook are very committed to going end to end by 22 and as well as going ephemeral. So to have disappearing messages, at which point that
What
content
what
is
do you
gone.
think that will do to the prevalence of CAM being shared?
Well, I know that the National Centre for for Missing and Exploited Children in the United States has indicated that if this does occur, it will drop the amount of or reduce the amount of reports that they receive by up to around 50%. That's a huge amount of material that will go undetected and unreported. And that's, and we know that, domestically, the AFP rely on open web sources for a lot of referrals as well, or the ACE do. So
Yes.
it's a really, it's a matter of great, I think, moral concern.
So I think it's fair for us to put to Facebook when we question them tomorrow that going this way will see up to 50% of this material that we're currently discovering potentially lost to law
Certainly,
enforcement.
and I think that's noted within our submission, those stats from the National Centre for Exploited and Missing Children.
Yeah.
It's a terrible acronym, sorry.
All right.
But
Can I
yeah.
can I take you back to your point about the limitations of these AIs then? Because obviously we hear a lot about this, particularly from tech companies and to a certain extent law enforcement as well. But what I don't want is to see the hype around the hype around AI being used by tech companies as an excuse not to put the resources in place in terms of personnel and also better controls on their platforms. So I'd really like to understand, well, to what do you think of the AI can actually achieve and its limitations, particularly as we currently understand it?
Look, AI offers amazing possibilities for a whole range of things, but it also comes with inherent risks. And it's something, I guess, a form of technology that's always developing. It's evolving so quickly still. And there are inherent, I guess, one of the great problems with AI, and I know Dr. Ali knows a lot about this, is the selection bias problems with AI, because AI programs rely on data and large amounts of data to be able to operate. So they're sort of trained on data. And using particular data sources. So, a great example is in the US, where AI has been used in relation, I think, to prediction of crime, and it will always go to a particular demographic because that's how the algorithms that operate the AI have been trained. So there are inherent risks with that, where the AI, if trained in a particular way, will miss anomalies.
So its strength is in finding look, I forget the names of it, but they're referenced in other submissions. Its strength is in the ones that can, for example, take a photo and search the internet and find them on other providers.
Yes.
But it's a lot. You're saying it's a lot more limited when it comes to actually, say, predicting behaviour or building a profile or finding somebody who may be offending but not necessarily sharing a specific image of which we're already aware.
It relies on the content and the data that it has. So when new data is coming in, it essentially has to be trained to be able to understand that new data.
So it's a realistic thing for tech companies and providers to rely upon in order to try and find material broadly on their platforms that already exist, but not so much to identify new material or to make those kind of judgment calls about people.
And child exploitation material is an interesting kind of area as well in this regard, because one of the things that look, like people talk about a lot, is dark web crawlers or web.
Yes.
So which can also offer some sort of solution to this problem, at least in detection. The problem, and I've spoken to some researchers that are trying to develop a dark web crawler for child exploitation material. But from a research perspective, to actually train the technology, they can only use adult images legally. And so they are relying on adult pornography to train the web crawler. So obviously when that goes into an agency or, to the AFP, they will then be able to use images within their, within their stores to I guess, train the web crawler in that regard. But as it stands, it is a really difficult, to get the ethics approval to be able to do this kind of work. And it's difficult and it's long term. And while it can offer some wonderful solutions, it also has its limitations in that it, as you said, can recognise a child in one video and a child in another video and a child in a photo, but it can't tell you much more about that child. It will just find the links in terms of how much that image has been shared.
Right. Can researchers not partner with the ACE to access that kind of?
That I believe
through
that
law
is
enforcement,
happening,
for example?
but again, it is a long-term
So,
process. And the other thing is too, they're reliant on the images that they have,
yes.
which is a great start, of course. But the other, I guess daunting thing, especially with child exploitation material, is that they are children and they grow up and they begin to look different.
Can I take you to your view in your submission about potentially expanding the definition of within the AVM Act to encompass more CAM material? This is something the committee's looked at recently, and and we did struggle with the issue of trying to shoehorn more into the AVM Act. It's trying to fulfil a specific function, but is your point that there needs to be a similar regime of penalties in relation to a broader range of CAM, particularly that relate to individuals in, say, tech companies?
Yes, so while you could try and, as you said, cram it in there, that might not be ideal, but there could be scope to create a new regime that deals specifically with these issues or similar issues in relation to child exploitation material. Because as it points out, I guess, in our submission, while some material could be captured currently, the limitations of the abhorrent material as it stands are, that it must, be rape, that there must be penetrative
Yes.
penetration,
No, certainly the
and
committee.
and the element of violence.
Yes, no, certainly the committee understands the limitations, and certainly the idea of picking up that kind of regime that the committee feels has worked well in relation to AVM and relating it to a broad definition of CAM has some merit in terms of exploring. Do you get the feeling that right now, though the tech companies, the individuals, are not being held responsible enough or don't have those penalties in place to comply? Are you seeing a lot of examples where they're not complying with law enforcement quickly enough or aren't incentivized to?
I couldn't comment on that specifically, and I think that's probably where the e-safety commissioner will be particularly helpful. But there is no doubt that tech companies are trying to take steps to deal with this, and it is a huge problem. However, we know that they could do more. I think.
But you've seen our new Online Safety Act that we're looking at, which creates an enforcement regime for the Safety Commissioner. But you think we need to go further than that, or do you think that Online Safety Bill goes some way to address those concerns?
Look, I think it goes some way, but it is still quite limited in its scope, and same with the trolling legislation.
Yeah.
While it's a great step in the right direction, it is still, I guess, limited. And in terms of with the trolling bill especially, while it might be useful for defamation proceedings and whatnot, when it comes to dealing with this kind of material, it's not really. It doesn't hold the tech platforms to account.
No, that's quite all right. I mean, there's a lot of lot of different things that we're doing in this space, and we're very cautious not to create duplication or overlap, but neither do we want to have gaps either. So that kind of advice to us is very helpful. Finally, can I, and I'll end on this because I'm out of time. Do you think we're focusing? Is there enough focus from in your mind from a tech perspective? Obviously, the Safety Commissioner and others and law enforcement are dealing a lot with tech companies and social media platforms. Are we neglecting the cloud providers where a lot of these images are hosted, who perhaps should be playing more of a role in terms of searching for images or being proactive at looking at their service, what their services are hosting?
Potentially, again, a very fraught issue, and we've seen what's happened in the US with Apple.
With Apple, yeah.
Where they have tried to start scanning images going through to cloud, and that was supposed to happen. It's supposed to be happening now, and it's not because of the backlash.
The Europeans are apparently kind of making steps towards that. Are they having a similar backlash? Do you know?
I don't know. I could take that on notice and have a look if that's helpful to you.
Yeah, no, look, if you can take on notice, if you think there's any further research around those kind of cloud aspects, hosting aspects of it, that would be great.
Mm-hmm.
All right, I'll hand over to you, Deputy Chair. I've done my 15 minutes, and over to you for a similar period.
Thank you, Chair, and hello, Anne-Louise. It's lovely to see you again. Thank you for your submission this morning. My questions around AI have already been answered. As well as around the AVM Act. So I'll move into some of the other questions that I had. And the first one is in relation to the link between online child abuse material and contact offending.
Mm-hmm.
Do you see currently the legislative framework that we have is effective in capturing individuals who are both accessing online as well as contact offending, or are there gaps in that space?
Well, I think, one of the, and there are no clear links as it stands. And I think that the AIC, they've done some fantastic work on this specific issue, and it's noted within our submission as well. So, and globally as well, while there are sort of, tentative links between the two, when it comes to like online only offending, it seems like they're a very different class of offender as opposed to contact and non-contact. So the AIC have done some excellent work in that space. In terms of the gaps, it's such a fraught issue because as we all know, this as it comes to child contact offending, it's a really underreported crime. And so while we're starting to see, I think off the back of a lot of work that has been done to bring to shed light on the issue of child sexual abuse, we are seeing a lot more people coming forward and a lot more historical cases coming forward, especially. But because the internet and this kind of ability to access these materials are still relatively new in terms of the history of the world. It is going to take time, I think, and a lot of longitudinal work to be able to work out what those connections are and how they can be addressed, be it via intervention or legislative levers. One of the, I guess, the things that strikes me, and this is just a personal anecdote, but I was a journalist and a court reporter for a long time, and I remember 10 years ago sitting in courtrooms, and the number of carriage service offences that were starting to come through at that time was quite daunting. So now, and I haven't been a court reporter for a very long time, but I hate to think now what the volume of those cases is, because at that time it was quite astounding. So we did a desktop analysis in terms of our submission, and I think found 47 mentions within a particular time frame or particular But again, that's just at a higher court level. You know, there's a lot of these matters going through magistrates' courts and local courts all around the country as they travel through to higher courts. And off the back of the pandemic, and I'm sure the increased detection of some of these crimes, it's going to be really interesting to see what that trend looks like. One of the things that I really actually want to do personally is do a bit of a mapping exercise of the increase and the changing nature of carriage service offences.
So is it the kind of that tenuous link, if you like, between contact offending and CAM offences? Is it because there's a lack of data?
I think that's
lack
a
of
huge,
empirical evidence?
yeah, that's a huge, really, I think there is a lack of data just because of the fact that this is still a relatively new class of crime. And again, this is just the crimes that are detected. Given encryption and the dark web, the amount of this crime that goes undetected is huge. So, as it comes to contact offending and online offending, it is hard to make those correlations. What we do know, and I think we've seen through a lot of the dark web forums, is that there is an onus on people when they go into those forums to provide material. And so that creates a really clear link in those kinds of instances around the sharing of child sexual abuse material online and the real life act of abuse. So obviously the Shannon McCool case in Adelaide is a wonderful example of that. There's another case mentioned in our submission, a grandfather who, Appleby, who was offending against his grandchildren and sharing that material online. And again, a very different kind of offender. I think one of the most terrifying or awful things about the Appleby case is, the fact that his name indicated that he was a grandfather and had access to children.
I wanted to just probe this a little bit further, this online offending versus contact offending, and this, I guess the defence by offenders online is that it's a victimless crime, that they're not actually doing any contact offending, but obviously they're watching in some cases we've seen that they're watching live offending, live rapes, sometimes in other countries or third countries, perpetrated by people in other countries. Do you find that this kind of defence or this perception that it is a victimless crime or less of a victim crime than contact offending, is that kind of pervasive in the way in which online material is approached?
I think that all of the research that has been done very much illustrates that, and the ACE have done some fantastic work in that space as well, around the fact that there's a lot of minimisation around online offending, that they're not touching somebody, therefore then they're not offending, which it couldn't be further from the truth. And one of the things I guess that is being shown through the research as well is that when it comes to online accessing of this material, there is an escalation of behaviour. So it will start off potentially as accessing adult material, and then I guess a person will become emboldened or want something different, and so they will sort of go down a path to where they start accessing child abuse material, but then they start accessing it a lot more frequently. And so, and the amount of images and videos that they will store is quite often, it's huge. I think that the average number of images has increased to now about 10,000 per offender.
Wow. I wanted to ask you about the McCool case that you put up as a case study, and in it, you note that McCool signed over his online identities to police, but he had to agree to that, didn't he? He wasn't compelled.
No.
Now, that was in 2015. does the suite of laws that we've introduced since then rectify that kind of situation where an offender has to agree to hand over rather than be compelled to hand over?
So it does with caveats. I think that that's the best way to put it. So while there is the compulsion now under Slade to, so there is the account takeover warrant,
Yeah.
that can still essentially be refused if somebody says, no, I'm just not going to do that. So then they get charged under, is it 3LA,
Yep.
where there is a maximum term of imprisonment for fail to provide credentials of 10 years imprisonment. Now that increased substantially from 2 years, I think, 1 or 2 years to 10 years, and that happened in the last few years. But in a case like McCool, for example, if the police had said, okay, well, we want to take over your account, and he said, no. And I'm sort of looking at this from, with Slade being enacted, it's very hypothetical. And he'd said no. And there was no way that they could get into those communications another way, then he would have potentially been charged with the offence of failing to comply, which
Just
would
10
have,
years
so
maximum.
taking that bet, saying, well, if I comply and they can access this material, I'm going to go to prison for 30 years. So I'm going to roll the dice and I'm not going to comply, and I'll get 10 years maximum. So
Yeah.
that's the caveat. And, so I think that criminals aren't silly, and people, that are, the amount of encryption and sort of self-destruct kind of functions that some of these kinds of offenders have within their personal devices is quite remarkable. And so, if Shannon McCool had not complied, it is very unlikely that police would have actually been able to access his computer, and hence, it led to obviously a global shutdown of the I forget the name. Sorry, the Love. The site, and numerous arrests in Australia and globally, and the rescue of children. So that's quite a terrifying thought. But it is something that ultimately could occur still, despite the wonderful, I guess, changes that Slade has introduced. With that, there is still, the right for criminals, or the criminals can still refuse and potentially get a much less severe sentence.
In the case of McCool, he got 35 years, despite being a leader of a worldwide dark web child pornography ring with 45,000 members and abusing at least 7 children in his care. In my opinion, 35 years is not enough. Do you consider that, and might not be anything that you've done research on, but are the penalties for the offences suitable?
I would be, I guess I couldn't really comment on that. That is something for courts to make the decisions in relation to those sentences. I think in relation to the McCool case, upon reading, it would appear that he did receive a lesser sentence due to his cooperation with authorities, and the fact that the information that he provided was able to have much far-reaching effects. But from a personal perspective, sometimes when you do read sentences that are handed down for particular kinds of offending, it is concerning. In that you would sometimes expect that there be more severe penalties, but at the same time, we don't necessarily know what information is being provided and what deals are being struck.
I have one more question, if I may, please, Chair, and that is with regards to the comments that you've made around the AVM and Slade and the trawling legislation. And while CAM is kind of included in that, so under the AVM, it comes predominantly under torture and rape. In Slade, it's really about compelling and takeover warrants. Do we need some real standalone legislation targeting specifically online child abuse material?
You can over legislate these things, certainly. I think that as much as this kind of offending can be wrapped up within existing legislation or rolled into existing legislation, that's certainly a good thing. That said, it is a unique kind of offending, and it's growing. You know, we know that this is something that's growing rapidly. So, you know, there is scope, I think, to be able to do that, and that would also potentially help in terms of actually resourcing policing of this. If there was sort of standalone legislation. You know, we have standalone legislation for terrorism.
That's right.
So, you know, there would certainly, in my opinion, be scope for child sexual exploitation material standalone legislation.
Thank you. Thank you, Chair. That's it from me for now.
Thanks, Deputy Chair. Over to Pat.
Thank you, Chair. And following on from Dr. Ali, Ms. Brown, you raised the issue, or not an issue, you raised that you were a journalist over a decade ago and you were a court reporter. Previously, I was a prosecutor, and you made reference to almost the floodgates opening back then, and now, I mean, there's so much material and so many charges going through the court every single week. Can I just get your opinion? Back then, everybody seemed to, you know, recoil at these offences and found it abhorrent, and the sentences seemed to be a lot harsher in terms of what was going on in the local court and perhaps the district court. Do you feel that over the past decade, or perhaps a little bit longer, that abhorrence has sort of been socialised?
I think that you are, or it's almost, in a way, a form of social conditioning, that it's something that, you know, people have become used to and almost desensitized to. The other problem with this is that it's not really something anybody likes to think about too much. Again, I'll point to some excellent work but ACE have done some fantastic work around that kind of sentiment surrounding this issue. And it's not something that parents really want to engage with, or that people more generally want to engage with, because thinking about it is horrible. But it also fails to recognise the sheer scope of this problem, because it's huge. And as we know through the research, Australians are voracious consumers of this material.
So, with your background, with your current position, and just as a layperson, do you think because of the proliferation of all this material, whilst we have, you know, sentences of 5 or 10 years or 15 years, do you think because of the amount that's out there, magistrates and judges are in fact giving fairly low sentences?
I couldn't comment on that, and I wouldn't feel comfortable commenting on that, because obviously every case is unique.
Yeah.
You know, I do think that within the courts, contact offending is taken more seriously potentially, but you know, I think that's all that I could really say about that. I'm not comfortable about commenting.
No, I understand, and I'll probably, this is a comment or maybe a statement. I feel, having had 30 years in law and law enforcement, that some of these sentences, being an ICO or CCOs, as they're called now, I think they contribute to that proliferation we spoke about, because there's no general or specific deterrence to offenders. And I think, well, if I do get caught, I'll get an ICO and I'll stay in the community. But again, that's just a statement. Thank you for your evidence.
Thank you.
Thanks, Jeff.
Thank you very much, Mr. Conahan. Well, just to tie things off, can I just ask? I'll just come back again to the encryption piece, if that's all right. Is there any other research that the CSC has done around, what might be appropriate regulatory or legislative responses from government, or appropriate responses to what seems to be just this inevitable march of encryption?
Well, again, it's such a vexed problem.
Yes.
It's something that we look into very deeply, I guess, from existing legislative and regulatory frameworks. But I think that the key thing to take away from this is that it has to be a shared responsibility. And so while government can legislate and people, or politicians and members of the public can jump up and down and say this is wrong, what it needs is for the tech companies to come to the table and to agree that potentially, like I said in my opening remarks, privacy isn't a given. And if you're doing the wrong thing, just like, we all know that if you're talking on the telephone, if you're a criminal that's talking on the telephone, you know that there is a likelihood that your communications will be intercepted. Why should that be any different for any over-the-top communications? It shouldn't. And it essentially creates the perfect ecosystem for this kind of crime to flourish and grow and be profitable.
But do we, I mean, realistically, as much as I'd want to make it big tech's problem and hold them accountable, believe me, nobody is more enthusiastic about that than me. But I mean, do we really have any realistic hope of pushing them away from encryption when it just seems to be, the way that they're all going? I don't see them turning their back on it anytime soon, as much as we point out the dangers.
No, I agree. I agree. And so obviously, there are certain steps that could be taken. I know, in terms of Facebook that and their move to go end to end, that the Secretary for Home Affairs, Mike Pezzullo, has spoken very strongly about this. And so there was a really good submission actually in terms of actually taking the legislative step to make them a carriage service provider, which could help. It was from one of the ANU academics. And so if you were to, I guess, classify Facebook or some of these other providers as carriage service providers, then there could then be onus for them to provide those communications. But again, it's something that would have to be tested.
It would open up more existing law enforcement tools, would it?
Potentially, it would, again, that is a hypothetical, but it is, it is a potential solution, because why, when, these kinds of, social media platforms are providing the new traditional, it's a new form of communication, it's the new normal of communication, then why shouldn't they then be classified as carriage service providers?
Okay. All right, that's great. Deputy Chair, do you have any questions? Yes, go.
Thank you. I've just come up with another question, and it's a bit out of left field, but I don't know if you can comment on it, Eloise. But it's more about law enforcement capabilities to use CAM or CAM offending in cases of domestic violence or child, what's it called again? Oh, my mind's gone blank, sorry. Custody.
Yeah.
Custody. And I'm thinking also about the Hague Convention as well, and the return of children in cases where there might be online offending. Have you done any work on that, on whether, the online child abuse material, online offending, provides any kind of substantial or comes up substantially in Hague cases, in child custody cases, or in other kind of family court cases?
That's not, no, we haven't done any work in that space, and it would be something that would be really difficult given the restrictions of family court reporting, that would be hard to, I guess, glean. That said, we do know that there are strong familial links at times, especially as it comes to live streaming. So, and that is, obviously the Philippines is a hotspot for that. But we do know that in Australia, this is something that happens as well, that there are parents that will essentially use their children as commodities. But in relation to your specific question, that's not not something that I am familiar with or that we've done any research on.
Okay. And just on that, the live streaming piece, if the offence occurs in the Philippines, as you say, it's a hotspot, what are the limitations of law enforcement in being able to hold perpetrators to account?
Well, it's
Because there are a
difficult.
number of perpetrators in that, isn't there?
Yeah, so it is difficult. I know that the AFP have done some fantastic work in working with Philippine authorities to actually tackle this issue within the Philippines. Slade as well, while it doesn't offer, a solution to prosecution necessarily, what it does do is offers disruption. So the thing with live streaming is that as soon as the live stream stops, it's stopped, and so it makes it even harder to detect where this is happening and how this is happening. So the disruption power within Slade is an excellent thing, because at least at the point that that it can be disrupted and stopped, and that can potentially, help, kill off the economy of it, so to speak. But there are the limitations, and yes, cross-jurisdictionally, so many limitations, and that's where I guess it comes to, authorities from nations like Australia going into other nations where there is known to be higher rates of child exploitation, and helping police that. And I think that is well established, especially in relation to, the AFP's relationship with the Philippine authorities.
But the demand predominantly comes from the consumer country, which is Australia.
Yes.
And, while you need the cross-country cooperation to bring to justice and save the children who are involved in this, do you consider that Australian laws at the moment are effective enough in capturing the perpetrators in Australia?
I think if they can locate them, then they are effective enough. But again, that's the problem when you're working, if it's a dark web live stream, and if you've got 10 viewers in Australia, it's really difficult to actually locate and identify those people. So obviously,
Go on.
yeah. So they do it on dark web. They can do it on a whole range of platforms. AUSTRAC obviously have a really important role to play in this regard, and that's something that they have raised as well, that the amount of sort of suspicious transactions that they would see have seen going to countries like the Philippines during the pandemic have risen, and they suspect that that's in relation to sort of live streaming of online child exploitation material.
On that, AUSTRAC using suspicious transactions, does cryptocurrency make that more difficult?
Cryptocurrency is, obviously something that everyone's very interested in at the moment. And again, huge limitations currently in relation to cryptocurrency in Australia. And that in relation to child exploitation, it would be very difficult, because you've got the $10,000 threshold when it's going in and when it's coming back out. So when you're talking about transactions that are significantly lower than that, I would imagine, in relation to, accessing this kind of material from overseas, it's probably not that likely to ping.
Right. Interesting.
But I am not a cryptocurrency expert.
No, but it might be something that we could explore further. Thank you so much. Thank you, Anne-Louise. Have a great day. Thank you, Chair.
Thank you.
Thanks, Ms. Brown. Thank you for your evidence. We'll let you go and we'll take a short break. Professor Broadhurst, thank you very much for joining us today. Hopefully you can hear that all right. I'm Julian Simmons. I'm the chairman of the committee. You've got Dr. Ali, who's the deputy chair in Western Australia, who's just coming back from the break. got Mr. Pat Conahan there on the screen as well. You've got two other committee members, Senator McLaughlin and Senator Antic, who are on the teleconference. They can hear you and ask you questions, but just without the video component. I've gone through a bit of formalities at the beginning, which I will just not repeat verbatim, but just very quickly. You know, it's an act of contempt of the Senate to give false or misleading evidence. And also, you know that this is a public hearing, so everything that you say is being broadcast live. If you'd like to give evidence in camera or confidentially, you are quite welcome to. Just make sure you request that of me before you say anything so that we can switch the broadcasting off. What I'll do is I'll get you to give your name and position in which you're appearing so that Hansard can record it for us.
Thank you, Julian, and good morning, committee. Thanks so much for giving me the time to talk to you this morning. My name is Professor Roderick Broadhurst. I'm an emeritus professor at the Australian National University.
Lovely, thank you very much. Now, Professor, we have your submission, so thank you very much, and we've all been through it in great detail, and we're keen to ask questions. But so without rehashing the whole submission, but by all means, you're welcome to take 5 minutes with an opening statement if there's particular things that you want to draw the committee's attention to or to highlight.
Thank you, Chair. Look, I will take a minute or so. Sorry?
Yeah, go ahead.
Just take a minute or so just to sort of highlight a couple of things that I wanted to perhaps try to focus on this morning if we can. We don't have a lot of time, but we've got enough time to cover the main things. So first of all, once again, thanks very much for the opportunity to meet with you this morning. It's very much appreciated. I first just basically want to acknowledge the fact that actually there's been a huge amount of work being done in the child protection arena, particularly the online CSAM arena, which is the part that I guess I want to focus on. My main purpose really is to suggest a lot more attention needs to be given to, if you like, the prevention aspects of what we're trying to accomplish here. I think our law enforcement agencies do a pretty good job. They work very effectively internationally, which is essential, as we no doubt know, and you'll hear more about that, I guess, later in the day. So my main object, I guess, is to suggest that Tor, this is this large anonymous platform, widely used for all kinds of both noble and not so noble purposes. The aggressive anonymity in that environment, I'm suggesting, could be flipped in a way that we can, in a way, reach CSAM offenders, online offenders and others through that medium. So I wanted to kind of highlight that. There are lots of other, I guess, issues we could take on, but this idea of trying to develop and deliver effective online treatment for child sex abuse online users, and to try to, if you like, engage them in treatment programs is one of the really interesting innovations currently underway. And I want to talk a little bit about the work that the Finns are doing, in particular around the We Protect survey and the amazing sort of kind of, if you like, results already from the redirection program, which is a program associated with their work. I'll give you a little bit more detail about that. The other thing I wanted to touch on, which is a really demanding sort of area of research, but with high potential for better understanding, better intervention and so on, is the role of these child sex abuse material forums. I mean, in the policing world, they're sometimes called boards because they're image galleries basically of offensive material, but there are other elements of these boards or forums which do enable us to understand much more about the behaviour, if you like, of these. I mean, there are a diverse group of child sex abuse users out there, so that gives us an insight which is really worth developing. And I guess the sort of third thing I wanted to touch on, if we get time, we did sort of mention a bit in the parliamentary submission that we made. And that's the challenges around detection generally of child sex abuse materials and what we can do in improving the way in which we detect online child sex abuse material. And I'm particularly thinking about the role of machine learning. I guess we would call it AI. We don't like to use that term, but perhaps help to do a lot more than what our current technologies, the crawlers and so on, that we currently hash values that we currently use. So they're the three things I'd like to sort of touch on. And I guess just to bring you up to date, I've just had some recent correspondence from our colleagues in Finland about the progress of the survey that they conduct, this rather nifty online survey, which is now, we've got 13,000 respondents already, and the kind of data that's coming out of that is quite compelling. I mean, for example, just based on that self-report data, we know that nearly 40% of the people that respond to that survey are seeking or having contact. So this is the divide between so-called contact offenders and non-contact offenders. But the really innovative thing about that, I think, is that accompanying that survey, which was on a pretty well-established Tor or Onion service dictionary. So that's a place you go on the open net, you type in, you know, what you're looking for, drugs, you know, malware, child sex, whatever it happens to be. And that then flags up the survey, but it also flags up this really interesting online program that the Finns developed called Redirection. And what's astonishing about that is, since that's been running as a pop-up in relation to that survey, 8,000 respondents have ticked on to that Redirection online program, 5,000 of them through the Tor darknet market. So what that's all suggesting is there's quite a bit of untapped need. And so that suggests that the more we move up the crime prevention chain, from a better word, we tackle, obviously the national plan has a role for offender treatment and improving evidence, as well as the responses to victims. But those numbers suggest that there's a really high level of untapped demand. And the question is, can we design effective online treatment programs for these particular types of offenders? I mean, we would probably use the consumers of this product, because we really need to, I guess, try to head them off. So that's, I think, really, really promising. Just those numbers alone. And just as a small point, the Swedes have been running a very interesting treatment program as well, but it's, rather than it being online, it's a supported one. So there's a counsel that's online and that sort of thing. So there's contact with a trained psychotherapist. That program, which started, I guess, back in late 2019, really got going in May 2020. That's oversubscribed and has now closed. So all this suggests to me and many of my colleagues that if we go upstream and try to, if you like, you know, intervene in the earlier stages of child sex abuse material consumption, we might be able to actually have an impact on, you know, the amount of abuse that goes on. We might be able to push people to this distance and that kind of thing, Julia. It's the sort of kind of model that we really need to be in, I guess, investing a bit more. And of course, these are child sex abuse offenders are, you know, it's an international, it's a global problem. So we have to work with our partners, which, by the way, I think the Australian government, federal agencies and so on, seem to be doing a pretty good job of. You know, they do some fantastic transnational policing operations we've talked about in other sections. So that's the sort of line I'd like to take, and just to put you up to date.
Okay, great. All right, well, let's launch into some questions. So if I could just pick up your point about de-anonymizing Tor or Onion, a noble kind of aim, but what are the practicalities of that? How would you actually go about something like that? Is there any jurisdiction around the world that's making inroads into it?
Yeah, look, it's a terrific question. I mean, Tor's designed to actually defend against that very problem. I mean, there have been some agencies, particularly, you know, I can give some examples in the drug area and also in the CSAM area, where joint operations have been able to, you know, use some kind of malware, user error, and so on. It's a bit haphazard in that sense. So some of the techniques that are available, I mean, the short answer, I'm sorry, Chair, is to say that it can't be done all of the time. You might be able to do some de-anonymizing around particular kinds of products or services. I mean, just recently, for example, the Russians started to cut off servers that were providing relays for Tor users, and that caused quite a bit of disruption. But the relay system also uses a private bridge model, which enables me to connect without a server privately to Tor. And I think from memory, we're well over 8,000 relays now.
There's some other submissions that talk about the effect of actually trying to shut down Tor, which is at least open source, may in fact drive them to even harder models for law enforcement to look into.
Yeah, that's one of our concerns too, actually. It's a bit of a balancing act, isn't it? I mean, one thing's worth saying is that the Tor community, for what the people who use Tor just for simple privacy reasons, they're not accessing hidden services. If I'm in Iran and I want to read the BBC media page, then Tor's the outlet for me to go to, so that other agencies won't know what I'm looking at. So a lot of it's used in that context. So, but look,
do you think there's a legitimate reason in Australia, in a country with our freedoms, that you would use such a platform that's so dedicated to de-anonymizing what you're searching for?
Well, that's a good question. I wish I think there are some circumstances. I mean, the classic example would be the sort of whistleblower issue. I can think of examples on Tor where you can report, sexual assault, or you can talk about, offences of the state, that sort of kind of thing. So that would be one of the things you would lose, I guess. The other thing too is that Tor is not unregulated. One of the findings that when we looked at the work done by the transnational policing agencies around fentanyl, I mean, it had a very significant impact. And of course, there's a lot of chat on the forums about, okay, how do we improve our operational security now that this is. They do temper what they. So we found fentanyl just stopped being sold on the main markets. It completely dropped out of the system, and most of the markets and services actually do, except for the child sex abuse material forums, actually ban that kind of material. Look, so I think it's a balancing act. I don't think there's a straightforward answer. My gut feeling is that there is a risk of pushing them into places like Signal and Telegram, the sort of things that make it even more difficult for us to track, this kind of behaviour.
One of the aspects I'm really interested in is whether we're doing enough to target cloud content hosting providers whose services might be used by CAM offenders to host material and then quickly delete it and very easily delete it before law enforcement can get access to it. You mentioned the European example where they're mandating or they're encouraging the scanning and might be moving to mandating that, which has been a very different experience to what Apple had in the US. Could you just talk a little bit more about the European example and what they're achieving?
Yeah, well, I think basically what's happening generally, I mean, your committee would know, members of Parliament will know there's quite a lot of interest in what we can do to regulate big tech. I mean, they're kind of parajurisdictional operators. They really are a bit of a headache. But the Europeans in particular, the Lanzarote Convention, which really outlines what the Europeans hope to do to suppress child sexual abuse material online. That's sort of if you like, driven the policy there. And so putting pressure on big tech to do what they can to scan for this sort of material is pretty vital. So they've been sending that. I mean, they are really asking industry, and I think probably Australia's tried the same thing. Can you self-regulate? What can you do to help us so that we don't have to legislate? But if you can't do what needs to be done in terms of regulating the so-called public space here, then parliaments will step in, lawmakers, and make that happen. So look, again, I mean, the appetite is there. The response of the big tech companies has been pretty wary. I mean, the Apple example, which I mentioned in the submission to begin with, just illustrates what those limitations are for big tech, or for tech companies in general. That's only so far they can go. I mean, Apple's idea of kind of screening for that material, you know, on your watch or your map on your Apple phone did cause quite a lot of alarm. But in the sort of forensic field, we were probably more concerned about how effective it would be and whether it would work.
Mm-hmm.
In fact, you've got to match it with one that's already stored in an available database, and we know that doesn't work that well. You know, with all due respect to the tremendous effort that's been done in collecting those images and comparing them and trying to trace pictures.
In the European case, though, where they have pushed big tech to do that scanning, is there any research that suggests there is a reduction in available cam or offences or anything numerical we can point to?
That's another good question. I mean, the problem is it's growing so fast.
Oh.
You know, all
So
those different. So my short answer is probably too early to tell. And as I say before, forensically, there's a bit of concern, awareness about just how effective those sorts of systems would work, particularly because they rely on, you know, identification of images, matching them, and then getting an authority in one of those jurisdictions. I mean, the European Union, obviously, mutual legal assistance is pretty straightforward with Europol and Justpol and so on, a bit like our Australian system. Clumsy, but sort of it gets there in the end across the 9 jurisdictions in Australia. So the short answer would be, look, not until I think the technology for identifying, detecting these images and matching them, until we know how to do that better using multiple methods, I don't see us really clawing back on the amount of material we're seeing. We might have an impact on some of the larger markets, but we've got this massive problem now with TikTok, the image sharing that the kids use, and that's opened up a really alarming vector for grooming of children, etc. So I mean, it's something we could. And the live streaming problem is huge, but that's something again that we probably need to look more carefully at. But it's not a problem on Tor because Tor's doesn't support Java. It's not very good at sort of rendering images and so on in that format. So live streaming, lots of delays. So people who want to live stream don't use that platform. They tend to use platforms like Signal and even WhatsApp. I mean, Facebook. I mean, there's just no limit to the platforms.
Okay, and look, just finally, in terms of the harm harm minimization strategies that you're talking about, or trying to deter people off offending before it occurs. So again, look, I mean, I'll be honest with you, I remain pretty skeptical of that, and other members of the committee will probably delve into that deeper in their time. But with the Swedish, I think it's a Swedish example, is it? Sorry.
Yeah, no, it's actually they're both the Swede and the Finns have attempted. Okay. The Finns are still running their totally online program.
Mm-hmm. So it's obviously, again, it'd be early days, but again, is there any research showing that people who do self-report, for want of a better term, and put themselves into these programs then change their behavior, or has there been some quantitative follow-up sort of thing?
It's an excellent question, Chair. Look, the evaluation of these programs is a really severe challenge from a recidivist point of view, how to do that properly and how can we confirm that? But look, the early data, I agree with you. Look, I didn't come to this willingly. I was very skeptical. Now, come on, give me a break. How is an online treatment going to sort of change anybody's behaviour in that sense? So I'd have to sort of step back from that and say that, look, I think it's obviously worth the effort. How effective is the moot question? It's a really good question. And the only data we have at the present moment is self-report data prior to the commencement of a program, 8 weeks later, 10 weeks later, a follow-up, evaluation of what's been accomplished. And the kinds of metrics that are being used are the sorts of things. How many hours have you spent, watching child sex abuse material? Do you have contact? And we do note that there's quite a significant raising of awareness and that there are reductions in consumption. The real challenge, though, that the Finns and the Swedes have found is that when you try to contact, when you want to contact a counsellor, the old telephone, the old confidential doctor system, worked in Europe quite well, but everyone's so paranoid in these secret communities, Chair, that even the idea that your voice could be recorded, and given the quality of forensic, digital forensic, audio forensics and so on, it's probably a fair fear that you could actually be identified. So there's a very great reluctance to actually have conversations, even if they are anonymous. So we've been relying on sort of the, for want of a better word, rather clever chatbots to help that process, and then using text. So that seems to keep the paranoia, if you like, under control. From an offender perspective, I can use that idea.
The other concern that I have is even if it was to work for the individuals, the idea that somebody could self-report and be treated for this, I would be concerned that would go some way to destigmatizing it more broadly in the broader community, which would potentially be very harmful. Again, with their trials, have they looked into the effect that it has on how the wider community views these offences?
Well, that's again, a question that needs probably a bit more research. Yes, but certainly the Protect Children Fins did quite a lot of work on that area, and it seems to me that, well, to sort of summarise it, I guess what's being balanced here is the harm versus the benefit, and the argument is that if you can persuade, because one of the interesting things about the data that's coming out of those self-report studies is how early some of these offenders report their exposure to pornography. And I shouldn't really, actually there's a good point, actually. We've tried to educate the public, think about these kinds of offences as child sex abuse. And so the word child pornography, I guess, is, one of the things that we're trying to move away from. So that there's early commencement. There is obvious signs that viewing online CSAM material does push people towards contact or wanting more. So interventions at that level. But your bigger point, though, is it how acceptable is it just for us to sort of reach out to communities like this secretly, I guess, isn't it really, and offer some help without really knowing what perhaps the consequences might be. So, look, I'm not sure. I think in the discussions we've had at the ethics level, there's been a lot of discussion just to get the ethical protocols through to get some of this work done. The committees have been quite fierce on that point. What's the benefit? Does this sort of kind of work? Will it save a child? And if it can reduce offending and the gravity of offending, and for sort of online users shifting to contact offending, then the short answer is we'll take that on board.
Okay. All right. Thank you, Professor. Sorry, I need to hand over to my Deputy Chair. Over to you.
Yeah, thank you.
Thank you, Chair, and thank you, Professor Broadhurst, for appearing this morning. I do want to pick up on the issue that the Chair raised, particularly around early intervention. And I kind of want to contextualise my question by drawing on the area that I know, which is terrorism, right? So if you or if an individual goes online and uses the internet or a carriage service to plan a terrorist attack, to raise funds for a terrorist attack, to recruit for a terrorist organisation, they are considered operative. They are considered a terrorist, right? What I'm trying to get my head around is how is early intervention possible even in this space when in accessing the material you are already offending?
Okay, well, the short answer is it really depends a bit on which jurisdiction you're in when it comes to child sex abuse material. So some jurisdictions it's not an offence to view the material, it's an offence to produce and distribute. So I think from memory, the German study or a recent study showed it's about 20% of jurisdictions around the world just didn't have those basic laws. So it's not an offence in some jurisdictions to view. Yeah, wow. So so of course, we're almost got a seamless sort of kind of global view on the harm of child sex abuse, but it's not entirely seamless. There are quite a few jurisdictions right around. There are a lot of jurisdictions, for example, that don't define a child in the same way as the Australian Parliament does. That a child can, in some jurisdictions, can consent to sex after the age of 13, and that sort of thing. So there's variations across the globe in terms of those sorts of details. And other agencies have talked a lot about the Philippines and the kind of problems that occur there. Those kind of developing countries can be exploited, etc. Yeah, so the terrorism example is an interesting one. There is a bit of an overlap in terms of techniques, I guess, forensic techniques about the way, and research you may say, looking at a terrorist forum is, apart from the content, very similar to looking at a forum that discusses drug use, particularly, or discusses child sex abuse material. But there are some interesting distinctions in the Tor community or Tor environment. There are lots and lots of these. I mean, I mentioned a few of them in the report, Lolita being a sort of a notoriously large one. There are lots of these boards or galleries where images are swapped and shared. And I mean, it's not much of a commercial business in that regard, Dr. Ali. So these people share the stuff because that's what they want to do. There is a little bit of money making around the live streaming area, but it's a small fraction of the business, if you like, of uploading and sharing these kinds of images. And of course, in order to join these boards or these forums, sharing an image is often a requirement to join that board. So you join the conspiracy. So I get the problem. These are offences, yes, and certainly in Australia there are offences whether you're in Australia or abroad, actually. But it's unfortunately not uniform. And a lot of the jurisdictions don't have a great deal of, for example, regulation of their, I think the chair mentioned cloud earlier, the services, the IFPs and so on aren't always as regulated as our own. So look, there is a problem in that sense. But as I understand it, especially having gone through quite extensive sort of ethical kind of review and so on, is that we can do that. This sort of kind of research, we don't collect images, obviously. And then, there are lots of ways you can wriggle, you can work around some of those problems. So it's bringing out a sort of bigger question, really, in a way of how do we actually get more researchers involved in this kind of work, particularly given the barriers, logical and quite correct barriers that there are about, working in this area. So I'm not sure I've answered your question.
No, I'm getting the sense from you, Professor Broadhurst, that international cooperation is key. And this, this fact that there are several jurisdictions where viewing material is not considered an offence appears to me to be a huge barrier in getting some international cooperation and some international, just basic kind of standards around the sharing of material, the viewing of material, and what constitutes an offence. It's a surprise to me that there are jurisdictions that do not consider viewing material constitutes an offence. And it brings me to my next question about this idea of the kind of the victimless crime, and the research that you cite in your submission and that we've seen in other submissions about the psychology of online offenders having more empathy to victims than contact offenders. And I'm wondering, in your suggestions or the research that you put forward around early intervention and the kind of using the Tor, would it not be more effective if somebody was going in and searching up this material, instead of redirecting them to a program or having them self-refer to a program, to have a pop-up that says what you're about to do is child abuse and there are victims, it is not a victimless crime? Would that be a more effective approach in, I guess, deterring people from going ahead and viewing material and accessing material?
Yeah, look, some of the research, I'm thinking of Jeremy Pritchard's work in particular recently, where they set up I call it a honeypot, the barely legal one, where, people self enrolled on that. And the deeper they went into the site, or the more kind of potentially offensive the site was, warnings were popped up like you'll be, if you go to this next step, you'll be traced. That just won't, look, it's a great idea. Look, I think we need to do that all over the place. It just, in the open net, and the more we can do that, because Pandora's box has already, for want of a better word, opened up. So all these platforms, and Pornhub, you name it, there's lots of these sort of sites that are in the open net that would be very valuable to have. But what's been happening, of course, is that the CSAM, the so-called non-contact CSAM users, for want of a better word, they're operational security savvy. They gravitate to places. Even the redirection survey shows us that they prefer to engage in an aggressively anonymised environment. So we need to do something else for that, what I would call the deep end of the pool of potential CSAM consumers and abusers. We need to hit both the open, clear net, as you suggest, Dr. Ali, and we need to do something different. There's no point telling a Tor user that he's going to be traced if he goes into this board, that he just knows, she knows that's just nonsense. So one of the keys, I think, actually, we mentioned it in the report, and I'm probably a bit keener on it now than I was even then. We really need to do the hard, heavy yards, qualitative work in the forums where we can do that. Look, because what's interesting is that these forums create, they provide a sort of a protection. They're a carapace. They're like a tortoiseshell, protecting the cognitions, if you like, the ideas of some of these users. So you've got, users that will tell you, or please tell on these forums, because one of the great things about anonymised forums is, people tend to be more honest, sometimes even brutally honest. And it's quite kind of interesting. It can be rather hard to sort of stomach sometimes. But look, so there's people there that talk about child love and that they're really child lovers. So the cognitive distortions, for want of a better sort of term, are quite significant. And the techniques of neutralisation, we would call them, and you're probably familiar with that in the terrorism, that also gets to play. So we do get deeper understandings about how these folks sort of operate and how they think, and that gives us some clues about how we might be able to treat them, particularly at the moment, since cognitive behavioural treatments, for want of a better word, are really we know that they're not 100% effective. We use those in correctional services. There's a lot of work done treating real contact offenders that are in jail or in prison programs. So we have quite a lot of information about that. But what I found fascinating was going onto the forums and reading what they were saying about treatment and about their treatment experiences, and so on. And that was so. Look, there's still quite a lot of work to be done in that sense. Again, it's qualitative rather than, obviously there are metrics involved, but it's largely qualitative. And you've got, of course, people on these forums using these who actually relish what they're doing. They see it's a problem with society, not with them. Children really, like sex and so on. So look, there are massive challenges in that. We just haven't done enough of the heavy-duty research, I don't think.
No.
Dr. Allen?
So I was contacted by a group of mothers and wives of offenders who had accessed online material. And their argument to me was, he was a good husband. He just looked at this stuff online and so, he didn't hurt anyone. And I'm wondering, Professor Broadhurst, if this kind of focus on the difference in psychology between offenders who access material online versus contact offenders hasn't actually blurred the lines for a lot of people, and whether we need to have a bigger awareness piece here about the fact that online offending is offending. Online material does have victims. It is not a victimless crime. And I'm wondering if you've done any research in that space, or if you could comment on that space, because I was quite taken aback by these women who were basically defending their partners and saying they never did anything because they didn't have any contact with the child.
Look, I mean, it's just to unpack that a little bit. I mean, there is this shift anyway within our society about, you know, trying to turn off the idea that this is child pornography and trying to get people to understand it might have been that's what we might have considered many years ago, but it actually is sexual abuse. It does have significant harm. And if you know about the survivors, quite distressing in all sorts of different ways, and the long-term impact can be very significant. So this idea that I'm not touching, I'm just watching, we need to turn that around, and so that people understand that the actual child in that image or that video, and if you think about some of the worst examples, the live streaming that we know about, that's pretty grim stuff. So we need to break that. It's harmless. And I think a lot of progress has been made in that regard. The point you raised, though, is when there is a child protection issue, it can have devastating impacts on the family. And so I guess because I'm sort of interested in the sort of treatment arena, we know from bitter experience that we need to have a very compassionate approach. We're not going to change these people by telling them to stop it now. I mean, look, with all due respect, that's a great program. It works brilliantly in many parts of the world, but it hasn't reached out to that group. So the group that you might think is potentially one you want to focus on is this group that is viewing this material. We know that viewing of the material escalates. In other words, that over time, that they're not satisfied. You have to go up, another notch, if you like, in the grimness of it all. So if we can intervene at that level, and we need a compassionate approach to sort of reach out and therapeutically, that of course is going to be at some odds with our moral and legal codes about what we do about it. But the impact on families of some of these child protection cases can be very long term. And I don't know that we perhaps underestimate just how much more effort we have to do to support those families.
Okay.
It's not. Yeah.
Sorry, Professor. Sorry, Deputy Chair. I've just got a hand over. We're running 5 minutes behind, but to Mr. Kind of hand for 5 or 10 minutes.
Very quick, thank you, Chair and Professor. You've been talking about treatment and quality work. You started off giving your evidence today and you referred to, and I quote, a nifty online survey. Unusual kind of terminology for when we're talking about CEM. Can you just explain to us, in terms of that survey, who drafted it, where is it, who's using it, and what are you doing with it?
Yes, thanks very much, Pat. A good question to clarify. Yeah, I guess the word nifty, not really a that you could use a long-running existing search engine called AMIA, which has been running since about 2013. It's a very well-established search engine, so you can go and find hidden services on Tor. And that's in the open net, right? That operates in the ClearNet. You can search it up. You'll hit that search engine. You can type in, I don't know, you might want to visit a Tor site that sells malware, So when you type in child sex or child or, Lolita or, some terminology, which is actually, that terminology is really important because it does change a lot, so-called argot, the language that's used. So you type in that and then it pops up and says, okay, you've tried to type in something to do with child sex abuse. Here's a survey that's developed by the FINS. We Protect folks under the Protect Children under the We Protect Alliance that funds this. What pops up is a survey saying, look, how can we help you how can we help you? Fill out this survey if you want. And by the way, at the same time, you get a pop-up message saying, look, there's an online treatment program. here available, through the redirection program, which is well designed online program. And so you can access that. So that's where the numbers are coming. So when I say it's nifty, it's actually very difficult to sort of find means to recruit people to self-report studies, whether it's CSAM or drug use. So that's what's the nifty part. It's using an existing hosting or even like a search engine. That search engine has been tweaked in a nifty way, if you don't mind, Pat, to let that sort of process work. And as a consequence of that, it's worked really well. So that's the innovation, I think, that's interesting. And it could be applied to lots of different fields. But the fact that when we ask them to kind of join the survey, we go through some really interesting questions like, do you have contact? When did you start seeing porn? What kind of children you're interested in? That sort of thing. It's quite a detailed 32 question format. Then rather than just leave them, we also want that, because often it causes a bit of disturbance. They actually start thinking about it. Many of these people will report they've never spoken to anybody. They've never talked to anybody. They thought about treatment, but don't know where to go, that sort of thing. So that just allows us then, obviously it's going to be imperfect, because it's not everybody's going to want to, in fact, a lot of them, 40% perhaps, just don't want any help at all. They basically relish what they're doing, get off on what they're doing. So we are really sort of kind of, I guess, reaching out to you might say perhaps treatment ready or looking for treatment or worried about the impacts of their interest in children, that sort of thing. So it's sort of in that sense, it's a good way to reach very difficult to reach populations. And we want to do more of that work for want of a better word, in the deep end of places like Tor, the really aggressively anonymised places where these folks tend to sort of confident.
Yeah. And just very quickly, is there any data on how successful that pop-up survey is with people going through with ongoing treatment?
Well, what it has been successful in terms of the data is the numbers that have actually logged onto the redirection program, and it looks like it's around about it varies. I haven't got the latest numbers because the numbers have gone up to around about 13,000 self-report users, and we know that about 5,000 of those have gone onto the redirection program. We're still waiting for outcome results, and the outcome results, just to be brief, tend to be focusing on how much time have they spent, what sort of kind of worries they have and so on. So look, it's early days, Pat, but maybe in 12 months' time we'll have more details to give you.
Thank you, Professor. Thank you, Chair.
Thank you.
Thank you very much, and Professor Broadhurst. That brings us to the end of our time, and we have our other witness with us. So thank you very much again for taking the time to work with the committee on this. It's an important topic, and we appreciate your passion.
Yeah, thank you, Chair. Thank you, committee.
Okay, Professor, can you hear me all right? Yes, give us a thumbs up. Perfect. All right,
Yes.
good. Well, look, we will kick off our next with our next witness. I'm Julian Simmons. I'm the committee chairman, and you also have with you Dr. Ali, who's our deputy chair, and Mr. Conahan, whose video is just turned off, but he'll be back in momentarily, I'm sure, just having a drinks break. You've also got on the line, but not on the video conference, Senator Antic and Senator McLaughlin, so they can hear you and ask questions, but they're not on video. Everything you say is public. This is a public hearing, so just be aware of that. If you want to give confidential evidence, you're quite welcome to ask. Just give me a heads up so I can turn off the broadcasting, and we can keep that evidence confidential. Can I get you to state your name and your position for the record, please?
Yes, Professor Benoit Leclerc from School of Criminology and Criminal Justice at Griffith University.
Okay, I'm in home quarantine. You look like you're similarly working from home, though you might have a bit better view than I do by the looks of it.
My apologies. I'm actually on leave.
Oh,
So-
right. Well, then we appreciate you spending your time on leave talking to us. Look, we all have your submission, and we've gone through it thoroughly, and we're very keen to ask questions. But by all means, I'll give the floor over to you for about 5 minutes if there's anything in particular issues that you want to highlight or to the committee.
Yes, I'll do that. I've worked in the field of sexual offending for about 20 years now, and I've also worked for about 5 years in a maximum security psychiatric institution evaluating sexual deviance and risk assessment of sexual offenders. So briefly, that's my background. We've just, in 2018 particularly, we got funded by the AIC to undertake a research on child exploitation online. Very briefly, what we found, first, we were really impressed by how dedicated the online investigators in Australia are in tackling this problem. We're also very impressed in their willingness to train, to learn, and to be provided more support to tackle this important problem. And lastly, we've just finished a study looking at the challenges of doing this work for online investigators, but also at training and support that online investigators judge from the perspective to be necessary to help them and support them in addressing this phenomenon. Very quickly, there were 3 dimensions that came out of this last study. That's the most recent one. From the investigator perspectives, the first important dimension to address in training and support was technologies and social media platforms. The second one had to do with learning about sexual offenders, the different types of sexual offenders, but also how they operate to commit their crimes. And lastly, the important dimension that came out of this study was to take more seriously the well-being of these online investigators in doing their work by different means. One was, for instance, by training them in terms of emotional intelligence and different other types of programs. So these are the kind of core dimensions that came out of that last study. Thank you.
All right. No, look, thank you very much for your work. I was going to ask this of our previous witness as well, but I just ran out of time. How are you finding your work? Because I think the academic work on this subject is very important. But how are you finding access to the information that you need? From 2 perspectives: how forthcoming are law enforcement to work with you? And how do we increase collaboration there? And then secondly, how forthcoming are tech companies because they're obviously doing a lot of internal research about what's on their platforms. They're releasing some very broad stuff, but not very much of it. If we were to, as a parliament or as a committee, look at ways that we would encourage them to release more of their internal data, how would that help with what you're able to achieve?
Yep. Well, at first, with police organizations, we found the collaboration to be excellent. So we have the opportunity to interview investigators across Queensland, Western Australia, South Australia, AFP, ACE, which is a new center in Brisbane for counter-exploitation of children. We didn't get to New South Wales and Victoria due to COVID, mainly. It was very difficult to get there. Collaborations with the police, I mean, like I said, we were really impressed with how dedicated they are. They take this phenomenon very seriously, but we also felt a bit disappointed in the fact that they don't seem to have that much support. Well, they could have better support and better training programs to address this phenomenon. But all the investigators we interviewed, they're very keen, making a difference. They're just asking for more training and more support, essentially. When it comes to technology providers, this is a bit more tricky. I haven't particularly worked with any technology provider on this issue yet, but what we seem to know through the eyes of online investigators anyway, is that collaborating with them can be extremely difficult, especially when there's a case an ongoing case, and in trying to identify that particular case, they're trying to get an IP address, they're trying to get to the bottom of that particular case to solve it. Often they will face lots of reluctance from the technology provider to provide the details to them in order for them to, make an arrest, identify offenders and make an arrest. Of course, technology providers have all sorts of privacy laws and legislations and privacy issues and so on. But still, from the perspective of online investigators, collaboration is not great. It's not great with technology provider, but in the end, it is essential. When you look at all the children now, all the teenagers, they all have a mobile device, they're interacting on social media platforms. It's a huge phenomenon. They're getting their mobile younger and younger, getting on TikTok and all these social media platforms. I mean, we need to find a way. I don't have an answer to this, but we need to find a way in partnership with police organizations to better work with technology provider. I'm not too sure how forthcoming they are. Like I said, I haven't worked with them specifically, but yeah, all I can say is that.
Welcome.
Yeah.
No, appreciate your perspective.
Yeah.
Can I switch topics a little bit? And your submission highlights the use of digital currencies by offenders. I don't look. You'll have to guide me a little bit on how deeply your work has been in this space, but it's something that the committee's interested in. Are you seeing a correlation between the rise of cryptocurrencies and CAM offences? Are they using it because it's harder to track or more anonymized, or what are some of the trends there?
Yep, there's definitely in the most recent years, I would say since 2018 particularly, we've seen a kind of a substantial rise in offenders using Bitcoins, for instance, to get access to the material. It really complicates everything because, as you say, there's an anonymity kind of feature that comes with it. It's more difficult to track.
Is it more difficult to track? Look, mate, I'm not a cryptocurrency person. I'll be honest with you. I don't own any. But I thought it kept a record along the chain of everybody who'd owned it from kind of day dot. The deputy chair shaking her head. She knows more about it than me, obviously.
Yeah, it's because from my understanding, people can create fake accounts and fake names.
Right.
A little bit like if you would, put up a profile on Facebook or on Instagram. You can create a fake persona. And offenders, they're pretty good at that because obviously they don't want to be seen. They don't want to be discovered, So using virtual currencies, as what I can see, add this extra layer of complexity for law enforcement to track them down. Even it can be tracked, but it's more difficult because they can use, again, different fake accounts and so on. And the way they would move the money around is not necessarily straightforward. It's not necessarily from point A, from account A to account B. It can be quite complex. It can come from one account and go to 3 different accounts. It gets really complex, and typically they would also use they would transfer a very small amount of money, so that it cannot come out as as a warning sign for I guess
it's not flagged.
Institutions to flagged from financial institution perspective. It's another layer of complexity for us to work around. I know financial institutions and especially the International Center for Missing and Exploited Children are on this. They're working very hard on this to design projects, to design case studies, or even typologies or transactional patterns using different cryptocurrencies that then financial institution can use to better identify what's going on when it comes to the movement of money. But it's another important problem because I guess 20 years ago, we would say offenders would trade material to get other material. right? I have produced some material. I'm going to trade that material to get some, I don't know, novel or fresh material, as they can call it, or whatever. Something that, you know, is new, is not on any social media platforms. They get into that sort of thing. But now we can see quite an important increase of individual, not necessarily sex offenders, but just individuals getting into this sort of criminal markets just to make money. So it provides another incentive for, we call them facilitators, to facilitate, get children do stuff, record that stuff, and send it to offenders to get paid for it.
Okay.
Yeah.
Can I ask, in your research, we've
Yeah.
been asking other witnesses about, particularly about AI or the opportunity for machines to do a lot of this categorization and sorting of CAM. I'd be interested in given your specific knowledge of law enforcement techniques and how it affects investigators. Is the potential there for this AI to take a lot of pressure off them individually having to look at images, or is it in fact creating more pressure on them because they've got to look at some of the harder cases that the AI can't do, or how are they interacting, I guess, is my question.
I think there's a stereotype in the field that kind of, not a stereotype, a preconceived idea that the problem for online investigators is viewing content as such. This is only part of the problem.
Mm-hmm.
The other part of the problem, and I think the major part of the problem, is investigators portraying offenders on the internet. They have to create relationships with them to be able to identify them down the road. This is, in the long term, I've worked with sex offenders for 5-6 years. In the long term, surely it's going to affect some of these online investigators. It's really difficult to, it's very difficult to like put up a list of warning signs when it comes to that, because the effects or consequences generated by being in that field are very subtle. They just can hit you like a wall at some point in your life when you're very stressed for different reasons. So let's say an investigator is going through stressful period with his family, he's having problems at work, or the workplace is very tense, and then you add a few layers of stressful events and stuff, then this sort of feel or this sort of content is more likely to actually affect them. Reducing the time that investigators would have to allocate at viewing this material is certainly a bonus. It's good. It's a good thing. But like I said, to me, viewing content is not. I don't see that as being the major cause of negative consequences to online investigators. It's way more complex. It has to do with the workplace. It has to do with how much pressure these investigators put on themselves to do their work, how frustrated they get because they cannot achieve their work properly, coupled with portraying to be an offender, to be able to create relationships with these offenders, to arrest them down the road. It's become a massive ball of stress for these people. And surely down the line, some of them will burn out and will have to be moved to another division, something like this. And since the other problem with that is that since we don't have a massive workforce of very competent online investigators doing this work, we have to protect them, period. That's how I see it. We have to protect these people. How many we have in Australia? I don't know, 50, 60, 70? We have to protect these people so that they can do their work properly, efficiently, and also stay well, not be affected by this sort of child sexual exploitation content and field in general.
Well, no argument here. So but you're saying the training the training they can receive goes a long way to supporting them. Do they feel like they can't keep up with the tech trends before them, or do they feel like that there just isn't enough training? They don't get those opportunities often enough.
Yeah, it's what you're saying, Julian. They cannot keep track because they don't get training and enough support to be able to keep track. Essentially, that's what it is. The technology is not needs to be updated. The amount of data that they would have to store when viewing content is just massive. And sometimes the technology is not just coping with the amount of data that they're going through, but there's also social media platforms, all the new innovations in the technological world that the offenders will use to their advantage to do what they're looking to do. Investigators need to be aware of that, and they need more training, definitely.
I don't want you to name and shame because I'm sure that a lot of them talk to you on a anonymous basis. But is there some jurisdictions that are doing it better than others, or is it a problem across the board that we just need to lift the training standards for all across the Australian jurisdictions?
Um, ACE is definitely on the top of the game. I would say ACE is really doing great. That center is doing everything it can to make a difference. That being said, what I heard from investigators is that there's no standardized training across Australia. So some of the investigators will receive the training and some others won't for some reason. Maybe because, I don't know, maybe because there's an investigator in Northern Territory and they don't have the budget to pay for him, to fly him over in Queensland to receive the training. As simple as that. And to me, it's just not acceptable. So all online investigators should be able to receive the same training. And I guess if you put them all on the same level in terms of training, and we can bring all these investigators across Australia in the same room, for instance, in the same event, well, we're also boosting the capacity to know each other and better collaborate on different cases across states over Australia. So it has many ramifications, but not all investigators, for various reasons, have access to the same quality of training.
Okay, excellent. That's been very helpful, and it sounds like the ACE has a good role to play. Deputy Chair, I might hand over to you. I've exhausted a bit of time there, and I'll hand over to you for a similar period.
Thank you, Chair, and thank you, Professor. Professor, I wanted to just pick up on the cryptocurrency piece, the Bitcoin piece. Do you consider the threshold that AUSTRAC has, which is at $10,000, is that a real inhibitor to AUSTRAC being able to collect evidence or track people who are accessing live feeds of child sexual abuse material?
So when you mean $10,000 threshold, do you mean in order to flag if there's a problem or not, the threshold they're using? What we can see is that, and the AIC has done some research about that, actually, the Australian Criminology, and what we know is some of these offenders will move money around, but in very small amounts, as $50 or $100, repeatedly. I think the repetitive nature of moving amounts of money from one account to another account should be flagged. And I'm sure I would imagine AUSTRAC knows that, is aware of that. So I don't think $10,000 is, unless they mean in a repetitive manner. But there's certain offenders are certainly, paying small amounts of money to avoid being flagged.
So we've introduced laws around anti-money laundering and terrorist financing.
Yeah.
That assist AUSTRAC? Do you think there's a need for laws to be introduced to assist AUSTRAC or some form of legislation introduced to assist AUSTRAC in being able to flag these kinds of small but voluminous transactions in this space?
I think so.
Okay, thank you.
Anything that can help, I see, to target this. It's a very dramatic phenomenon. Anything that can, yes.
I wanted to refer to, in your submission, you talk about the specific ways in which CEM offenders consume, distribute, or produce material. And you go through these stages: searching the open web, finding the existence of dark web, setting up access to dark web, entering the dark web, accessing CEM content, protecting their identity, engaging with other members, consuming and/or distributing. Now, I want to get your opinion on this in light of the evidence that we heard from Professor Broadhurst prior to your appearance here around early intervention. Is there an argument here that, given these steps, there is a very real intention in accessing CEM that involves actually going into the dark web, actually setting up access, actually protecting your identity in order to set up access to material, that in and of themselves are indicators of intent to commit a crime, and therefore the question of early intervention is problematic?
Early intervention, can you be...
So the idea of being able to intervene early to stop someone from committing an offence, given that the stages to committing an offence actually involve purposefully hiding your identity.
Yeah. So you're not talking about early intervention at the individual level. You're talking about
Professor Broadhurst talked about programs where they capture people who are viewing or accessing CEM and putting them through, I suppose, rehabilitation or behavioural kind of programs online.
Yes. Yes. So you're asking me if that's effective or that's...
Yeah, I'm questioning whether if there's so much intent involved in accessing the material, how effective does that render any kind of early intervention? Because in accessing the material itself, you have to set up, you have to hide your identity. You have to go to the dark web. You're not doing that for something innocent.
Yeah, but that's the dark web though.
Yeah.
So we have the clear web as well.
Yeah.
So Professor Brothers probably talking in line with the clear web. You're absolutely right in the sense that offenders getting into the dark web, obviously they have this intention. That's what the dark web is designed for. Those communities on the dark web, that's what they designed for. They design offenders to interact with each other. But on the clear web, that's very different question. So I do think what Professor Brothers is doing, I think it is helpful because early intervention like this might prevent some offenders from escalating down the road. And that's really important because what we can see is that there's a transition for offenders to move from the clear web to the dark web at some point if they get too deep into it, so to speak. And sometimes you would have dark web offenders trying to recruit clear web offenders, if you know what I mean. So dark web offenders would be a bit more techno savvy, if you like. And if they can identify some offenders on the clear web being, if you like, doing a lot of involved in many criminal activities around that, they may actually identify that person and flag to that person the risk of committing these activities on the clear web and bring that person to complete those activities or to maintain these activities on the dark web so that that person doesn't get flagged and arrested. So it's
So it's kind of a form of recruiting, like terrorist recruiting, right?
yes, they can do that. Definitely, they
Mhm.
can. So the research that Professor Broder is doing essentially is trying to break down the whole cycle in a way at a very early intervention point where offenders don't even have the possibility to escalate.
Mm.
I think it is important. How successful it can be, it's difficult to know because we're breaking down the chain very early. So you cannot know if I've prevented Joe and Tom, from accessing different material on the clear web, would never know if they would have went and commit more criminal activities on
Mm.
the dark web. We can imagine that would be a strong possibility, but we just don't know.
Mm.
Yeah, so I do think it's important.
The other thing that Professor Broadhurst mentioned was differences in the way in which different countries and international jurisdictions approach this. And he mentioned that there are around 20 jurisdictions that don't consider viewing child exploitation material online as an offence. They
Yes.
only consider producing it as an offence. Can you make some comment on that, and particularly in relation to the challenges that poses in Australia for law enforcement?
Yeah, I've seen that as well. I've heard that there's some countries not really keen on collaborating, or they don't have the capacity to collaborate, put simply. I know Mexico, for instance, is one country where collaboration is extremely hard, to complete or to do with them. That touches on international collaborations from the Australian perspective here. Often Australian online investigators here are asked to help and collaborate with other countries because the other countries simply don't have the capacity or the skill set to identify an offender, for instance. Even from Canada would do that, would reach out to Australia from time to time. However, there are two important dimensions to that. I think international collaboration is really important, but it is difficult to achieve depending on the country, as you say, depending on their laws, but also it puts an extra stress on online investigators in Australia because, like I said, how many investigators do we have here? 60, 70, 80? These guys don't have time to do their work. They're just asking for more time to be able to do their work more efficiently. And when they're asked to collaborate internationally, they're very willing to do it, but they have to put a case on the side and then focus on another case. There's a real need of more human capacity in terms of online investigators to work in this field. We did thousands and thousands and thousands of offenders.
Yeah. Yeah. And on that, do you see a role for machine learning or artificial intelligence? There are certain challenges to the use of AI or machine learning, whatever terminology you want to use. Do you see that in future there will still be a very heavy reliance on the human factor, on human investigations, as opposed to a more reliance on artificial intelligence?
Very good question. We always need the human factor. Investigators, they know offenders best. In the line of their work, they do have to know with who they're dealing with. So the human factor, a machine could not make judgment calls like this, I don't think. I guess AI and some of the technologies can help, reduce the amount of work they have to go through or the amount of exposure to CM and things like this. But in terms of decision making, that remains a very important human factor. And I don't think we can replace that.
And just one final question, please. We haven't heard
Yeah.
a lot about the relationship between grooming
Mm.
and offending, whether it's contact offending or child exploitation material online. Have you done any
Yes.
work in that kind of relationship, and can you make any comment there?
Yes. Obviously, as the number of offenders increases dramatically online to view content, what comes with that is that some offenders may never have thought of having sexual contact with a child, but because they're getting exposed to so much content and because they're able to establish relationships with other offenders interested in having sexual activities with children per se, some offenders can start online, so to speak, and then escalate in the real world and actually sexually abuse a child, maybe just to have the experience of having sexual contact with a child, maybe just to produce, record the material and then trade it for other material, maybe just to gain status, particular status. So there's no, I don't think there's any research like providing strong empirical evidence on that particular, because it's too early and it's actually difficult to collect data on this. But we can see, and it's quite logical in the sexual offending field. There's always some sort of escalation for a number of offenders. And the problem with that is that, yes, some offenders may start easy, but then they may move on to produce sexual offending material themselves.
And is sorry, is the psychological process here that we're talking about that if somebody starts offending online and they become, we've seen that the psychology of online offenders tends to be that they do have more empathy to victims. But if they are accessing excessive material or large volumes of material, do they then become desensitized and become less empathetic to individuals, and that drives their behavior offline to contact behavior?
It could be. By viewing so much material, it's like they want more.
Okay.
More. They could start with very simple images and then escalate to like more and more, I don't know, intrusive sexual activities, pictures and things like that. It's a possibility, definitely.
Thank you. Thank you, Professor. Thank you, Chair. That's all from me.
Thank you very much. Mr. Conahan has indicated that he hasn't got any further questions. So I'm just going to ask a final couple just to round things off. Again, the AI, the hashing technology that your submission talks about, it also talks about some of the limitations in relation to that, about how it might be limiting new material being found depending on the way that various companies employ them, and they employ them at different times and all the rest of it. Can you talk to some of the trends in that regard?
Not particularly, no, unfortunately. This was more in line with the expertise of my colleague Tom Holt.
Okay.
Just being purely honest.
No, quite all right.
Yep.
All right, well that's good. Well, look, on that basis, then I'm happy to leave it there. If there's no further questions, then that's great. Look, thank you very much, Professor. Thank you for taking the time out during your leave to come and speak to us today, and we really appreciate your time.
No problem. It's a pleasure. Thank you.
Thank you. Bye-bye.
Bye-bye.
Okay, we're running a little bit early. Yeah. Does everyone want to take a break until 1:15 and come back? Bit of a drinks break? Yep. All right, let's do it. See you at 1:15.
Hello.
Yes, who's that?
It's Glenn.
Oh, Glenn, yes, we can hear you, mate. We just can't see. Oh, now you're back. Excellent.
Right. Is there a way to use virtual background? Because the option's not here. It usually is in WebEx.
Oh, mate, smart heads than me will answer this. Sean?
No option. Sorry, you just get your ordinary background.
Right.
It's all right. We get to look
Apologies.
at your fancy games, mate. Looks good. Looks
Well,
comfortable.
Yeah, mate. It's the kids game room, but okay, no
Sure,
worries.
sure. Yeah, well, that's all right. Well, I'm home quarantining, mate. So none of our well, I'm locked in a bedroom away from the kids, so none of our surroundings are that salubrious. Glenn, we'll kick on. Mate, thank you very much for joining us today. I really enjoyed reading your submission, and Project Karma sounds like it's doing some incredible work, so congratulations. Just by way of formalities, this is a public hearing. Everything you say will be made public and broadcast. If you wish to provide us with confidential evidence, you're quite welcome to, but you've got to give me a heads up so that I can turn the broadcasting system off. And obviously, it's an act of contempt against the Senate to give false or misleading evidence. So I remind you of your responsibilities in that regard. I'm Julian Simmons. I'm the chair. You have the deputy chair, Dr. Anna Lee, coming at you from WA. You've got Pat Conahan there as well. And you've also got Senator Andrew McLaughlin and potentially Senator Antic on the teleconference so they can hear you and ask questions, but without the video. So we've all got your submission. We've read through it. We're very keen to ask questions. But mate, you're very welcome to make an opening statement for the first 5 minutes to give us your thoughts on priorities. And just at the start, if you could just give us your name and your organisation for the record, and then by all means launch into your statement.
Sure. My name is Glenn Hulley, and I'm the founder and CEO of Project Karma. Project Karma is a registered Australian registered charity, starting in 2016, and also has branched to become another organisation in Indonesia, of which I'm the founder there, which is called Yayasan Project Karma Indonesia. I don't plan to take up time in an initial speech. A lot of it is in the initial 5 minutes would be covered in my submission, and I'd like to give the committee as much time as possible to answer any of their questions. So unless there's anything specific in my opening remarks of my submission, I'd like to reserve that time for people to ask questions.
Great. Well, we'll kick off. I'll take the liberty as chairman of going first, if you don't mind. Can I ask an introductory question to kick things off? We hear a lot from law enforcement and often academia in this committee, not so much the NGOs, so I find it really interesting. Can you give us a bit of an idea of what the NGOs achieve in the child protection space, and how you work with law enforcement? Are you additional resources for them, or are you in fact able to achieve some things that law enforcement can't and in a quicker time frame?
Sure. To answer that in a brief way, I would say a bit of both. Over time, I can't speak for all NGOs, I can speak for my own, but I have coordinated with and consulted to, and in some cases worked for different international non-government organisations in this space, particularly child sexual exploitation. And I have seen that there is a definite need for the types of services that can be provided. I see them as filling gaps that I've identified, some of them in this submission. And I think that NGOs play an important role between connecting community and social issues to government and law enforcement. And I think that's an important component when we look at this in a holistic approach, as this problem is a global problem. So I think there are many international non-government organisations that have established themselves with reputation, credibility, that are already working with many different law enforcement agencies and government agencies. This is an example too where NGOs are open to be able to give submissions to government inquiries, government committees, and I see that as a good thing. It's definitely developed more and more over the last 7 years that I've been involved in this space. These types of things were not happening 7 years ago in Australia, and we're seeing other things emulating similar to what we're doing in Australia, which is fantastic. But there's still a lot of work to do, as I'm sure you're aware. So I see that NGOs can play different roles within different what we approach as pillars. We mentioned in the submission about Project Karma's Sentinel model and the pillars of focus that we look at. NGOs can assist in all ranges when it comes to this, addressing this problem globally and working with government and law enforcement. the first pillar being, you know, education and awareness, being able to run programs at grassroots level with schools and communities, which is what we're running as a pilot in Bali at the moment, to show that this can be done in any country if countries are willing to work together. So we're running these programs in different age groups in Balinese schools. That was part of a 2-year study, a working party that consulted with local communities, school authorities, you know, all those types of things, to come up with a program that was that is authorised, you know, by local culture, religion, all those types of things. So these are local programs that NGOs can run and assist by bringing in the local government resources, not necessarily national, and that's where I think NGOs work very well.
Yeah, certainly. Look, certainly in the awareness and education piece, we obviously have a lot of NGOs who are very mature in that space. But yours also has a bit more of plays a bit more of a hands-on role, I guess, for want of a better word, in terms of tracking offenders. And I was interested in your commentary and your submission that you often find yourself using the public reporting criteria to the ACE, for example. And so I know NGOs who play a more investigative role is something that other jurisdictions like the US have a lot more history with. And I wonder if you could give me some commentary about whether our law enforcement agencies need to catch up with that and be a lot more constructive in NGOs who actually want to play an investigative function.
Sure. I think, when it comes to domestically working closely with law enforcement agencies at state and federal level, there's a lot of hesitancy on their part in relation to, there's a lot of red tape when it comes to that type of thing here in Australia. And some of those barriers don't exist in other countries, which is where we operate as well. So it's a very difficult process for us where, you know, we can have relationships with another international government agency or law enforcement agency where there's a free flow of information, there's a level of trust. You know, we supply that information and we're able to confirm certain things to assist to provide more information because we're on the ground. But that comes from established relationships, and in some cases, memorandum of understandings in those countries have to be signed with law enforcement, things like that. Whereas, you know, Australian law enforcement agencies won't, as far as I'm aware, and I've been told point blank by the Australian Federal Police at the embassy in Bali, that they won't sign an MOU of any sort with any NGO, and so therefore, you know, their hands are tied too. I mean, as you're probably aware, Australian Federal Police don't really have any powers internationally as far as, you know, they're in another country and they're bound by that country's sovereign law. So essentially they're there just to assist and be a facilitator between law enforcement information when required and be a presence. So when it comes down to a physical, you know, a real life example, you know, there might be times where we've wanted to confirm certain things in order to provide accurate information to both Indonesian law enforcement and the Australian Federal Police. But unfortunately, their hands are tied in that, you know, there's a lot of bureaucracy about privacy and how they can share information, and particularly with a non-government organisation. So, and we've highlighted that a lot in our submission.
Well, yes. I mean, you gave us a good case study. I thought the Walbren one, for example. So yes, you've highlighted the issue, but I guess what I'm trying to get to is this a matter of practice, and, you know, and forging those relationships with the AFP, for example? You know, does the committee need to give them recommendations about operating procedure, or is there legislation that you can point to that is, you know, in part or whatever?
I was shown policy, and I believe it was Australian Federal Police policy. I can't quote where that has come from, but some internal Australian Federal Police policy is what I was shown, that dictates that there's no MOUs, memorandum of understandings, as such, to be signed with non-government organisations. There's no mechanism for them to be able to do that. So, whereas other countries, that's quite different. You know, yes, there is quite a scrutiny and process involved and time in developing that relationship, but those opportunities exist. So, That doesn't really exist as far as I'm aware, especially for when we're talking about international type activities where, if we want to work with Australian state or national police or federal police, sorry, it's quite laborious task and very hard to have a free flow of information, which, like we've highlighted in the submission, I also understand the other side of that. So, we've tried to present some options that may be open to the government to look at that could improve that situation.
Which jurisdictions are doing it well? Which ones would you like to see us emulate?
I think, look,
That collaboration piece, I mean, yeah.
sure. I think the US are working really well with international partners. Look, I don't want to take away what Australia is doing with international partners. I commend what the government, the Australian government, and also the Australian Federal Police have done over the last 5 years that I've seen personally. There's been massive improvements in development of relationships, resources, training, between international law enforcement agencies with the Australian Federal Police, and the formation of the Australian Centre to Counter Child Exploitation, is just an extension of that, which has built the platform to now really extend out the feelers, so to speak. And we're seeing this as NGOs. We're seeing this, in the industry, if you want to call it that. Where it's having a massive effect. So, the US has emulated something similar with the Philippines under their PICAC model, which you may or may not be aware of. That involves using an NGO, which is International Justice Mission. They've got a long and established relationship with Philippine law enforcement, and the Australian Federal Police have had a long established relationship with Philippine law enforcement. So the three of them have come together and over the last few years have formed this PICAC model, which is basically a centralised system of managing intelligence, cases, and following through, coordinating between these two international agencies. So that's another great model that's emerged in the last few years. And this is what we're saying, is there's been some great work in this space, and it needs to continue. There's still room for further, which we're highlighting in the submission.
And you've also worked closely with a lot of tech providers like Facebook. How have you found their engagement in this space to be genuine? How forthcoming are they with their own information about what's going on their platforms?
Yeah, it's a big animal, Meta as they're now called, encompassing a number of major platforms and taking up a very huge space in the social media market, the global social media market. What I can say is, early days in this space, we had grave concerns with Facebook and how they were managing, these types of matters, not just child sexual exploitation material on their platforms, but grooming through their messaging systems, forming of like-minded groups, whether they be pedophilic or child sex offender type groups, and sharing of child sexual exploitation material between each other, and these platforms that they own, being able to facilitate that and really not having many mechanisms in place. And my organisation and many others, made a lot of noise about this 5, 6, 7 years ago. And Facebook had to respond. Other governments around the world started pointing fingers too, where, look, I can understand a company the size of Facebook, this type of thing, there's no profit in it. It's only expense. And as you know, companies like this are solely focused on profits for shareholders. Engaging in investment of safety type systems into their platforms is really just an onerous task they have to do. Well, it has been in the past, but I think, when you get the head of Meta or head of Facebook at the time hauled before a Senate hearing and questioning, I think that's where the road started to change, and these companies, Facebook, I would say, led the way on it, really began to invest a lot of money into their safety and trust divisions, hiring ex-law enforcement, developing regional headquarters around the world, and putting in software, AI, which is still in its infancy and still being developed, but algorithms and other mechanisms, if anything, to protect their licenses and not have this type of material on their servers. And we highlight a lot of that in the submission. So I'm not sure how much detail.
Well, I mean, look, we're obviously able to judge the trends and some of those policies that they're taking up. I guess what my interest is how you're engaging with them. Are you going through public reporting methods with them? Do they give you a case officer? I mean, AFP and E-Safety Commissioner report quite a good relationship with some of these tech companies that are very responsive, but then you get down to individual jurisdictions like VicPol, and they're saying that their things can take 6 to 24 months. How responsive are they to the NGO sector, or in your experience?
In the past, I would say disgraceful, to put it simply, and I think you probably get that across the board from whether it be law enforcement, government agencies, or NGOs dealing with them. But I must say that has changed, and it's part of what the this Trusted Safety Partner program is that they've introduced. We're happy to provide some confidential information separate to our submission if the committee is interested in how that works. We're not held to a non-disclosure, but as part of that agreement, we've been asked not to publicly make it knowledge quite regularly. We did receive a grant recently from Facebook after 2 years of being part of this partnership, which they've given to a number of NGOs to recognise the work that they've been doing in this space for them. So that's essentially, they've been getting free services from these NGOs for quite some time under this arrangement. So to answer your question, essentially what happens is under this agreement, a special portal has been set up by Meta, whereby selected NGOs who have gone through a process and then an onboarding, another onboarding process, a selection process, and then an onboarding process, are then given access to this portal. And so basically we can report any posts, pictures, videos, private messages that across any of Meta's platforms. That includes WhatsApp, even though that may be an encrypted platform. There is still ways in which to identify a person, even though you may not be able to get the messages from the offending end. Screenshots from the victim's end are quite often sufficient, whereby we can still get IP information. Now, I'm not technically into that to that level, but that's the information we're given from Meta. And essentially, when we've come across ourselves, and they have teams of NGOs like ourselves where we may have a few people as volunteers that have gone through this process of selection, and are trawling for this type of material, and report it regularly. And so that's an assistance to their AI and algorithms and back-end things that they have in place already. But we also act as a port of call where members of the public or users of these platforms will come and contact us and provide information. And that will lead us to offending types posts and messages and things like that, which we then have to report. Firstly, we have the law to consider as to if there's been a crime committed. And secondly, there's the Facebook community standards, which is basically what this partnership works under. So they have their community standards, which you're probably aware of, and that's an ongoing project that they run, and they have a whole division, dedicated to that side of things.
Yes.
But essentially, that portal allows us to report that material. It's handled in a much more timely manner by a real person, and a determination is made on what needs to be done. And that's usually their Safety and Trust Division that makes that assessment. And it's then forwarded, if needed, to their law enforcement response teams, which is part of their system. If you're aware of Facebook's, safety system, how it works.
Sorry, I've got to hand over to my deputy chair in a minute. But one last question: that portal approach, is that something that just Facebook adopts as best practice, or are the other big tech companies emulating that, or that?
At the moment, that's Facebook it's a trial run that Facebook's been running for 2 years, and we've been part of it. And I think there's about 15 NGOs that are included into that into the group, and we've been pushing for other safety and trust divisions in these platforms to pursue the same mechanisms essentially. And I haven't seen it happen yet. We've had talks with Discord, we've had talks with TikTok and Roblox. But as far as I'm aware, no, that's not occurring.
Okay. Great. Deputy Chair, go. No, you're still muted.
Okay, now I've got it.
Oh, yeah, good.
Now we can.
It's computers and it's not a touch screen, so and I
No
was
worry.
thank you very much for your evidence today. You raised my interest there when you mentioned Discord, because I've done a bit of work on Discord as a real grooming platform for terrorism. Are you seeing that Discord is being used more for grooming, or what other aspects is it being used for?
Yeah, we've definitely seen examples of that happening, and I know other NGOs have as well. It is a concern. It's a very popular platform for kids. I'm not detracting from your statement. I do agree. I've heard of examples of that with terrorism and other extremist type activities. It's a platform that can create an echo chamber for whatever movement or ideology there is going around, and it's quite a popular platform as you're aware. In relation to this with children, the danger that we see, a huge red flag that really doesn't get spoken about a lot, is that whilst Discord is a completely separate company to the company called Roblox, which is a separate gaming company, as you may be aware of Roblox and what they do, they're completely separate companies. However, I haven't seen a child yet that plays Roblox that doesn't use Discord, in order to communicate with their friends while they're playing. And the two companies' products go hand in hand. And through discussions with both of these companies in the last 12 months, particularly during the pandemic, I've had good correspondence with them. They are acknowledging this, and they are starting to talk, and they're showing evidence that they are talking more. But I'm yet to see physically any changes occurring. I mean, you would think the word would be coming out to NGOs that they're consulting with different NGOs. I would hear of that. I'm not. So just as an example, but I really don't think much is happening there. And I think there needs to be more pressure globally upon both of those companies to act responsibly together. Because up until now, they've completely been treating this as separate. And I don't think that's the right approach.
Yeah, I agree with you there. I also think there hasn't been a lot of focus on the gaming platforms and gaming chat rooms in this space, which kind of brings me to my next question, because over the course of this morning, we've touched on kind of the different aspects of offending. We've got grooming, we've got the development of groups or organisations, if you want, transnational, international. We've got viewing of material, we've got producing of material, we've got acquisition of material through live streaming, for example. We've got sharing of material. There are a lot of aspects to this. Do you consider that our laws and our programs are comprehensive enough to cover all of these different aspects of offending when it comes to online child abuse material?
In short, no.
What's
a
missing?
little bit more of an extension upon that is I also can't offer a silver bullet solution. I think it's a very, very complex problem. I mean, we're not even touching upon anything that's occurring on the darknet and how people are accessing, different things there. We're just talking about public apps and platforms that are used by the majority of people. However, there's a lot of these crimes being committed through darknet, and we haven't really even touched upon that in our submission. And I hope there are others that you've heard from in relation to darknet activity for these crimes. So when it comes to legislation, trying to come up with solutions for all of that, I guess that's why I'm not a politician, right?
It's not easy for us either.
I do empathise with the government's position on this, because clearly more needs to be done. But that is the question: what needs to be done, and where do we do it? So I can't say I've got all the answers. I hope our government can, from listening to people like me and others much smarter than me, can come up with some better ways to protect our kids better, because there's some real problems and it's getting worse.
Yeah, so on that, we've got kind of separate legislation for terrorism that looks at a range of terrorism offences and a range of behaviours associated with terrorism offences, whether it's viewing material online, sharing of abhorrent violent material, planning an attack, participating or being part of an organisation, travelling overseas for the purpose of becoming a foreign mujahideen, etc. But when it comes to child exploitation material, if you have a look at the abhorrent violent material legislation, which we've just reviewed, the majority of the reports coming through that legislation relates to child abuse material, but under the categories of torture and rape. Do you think that we need to be looking at standalone legislation that
Yes,
targets specifically these
Yes.
kinds of behaviours, the grooming, the group development, the viewing, in the same way that we have standalone terrorism legislation?
Yes, I do. To answer that briefly, yes, I do. And I think it needs to be national. I think it needs to be then adopted at state level. We've tried to highlight that in our submission about the disjointedness. But I think what you're referring to in relation to terrorism, and I do understand where you're going with that, I believe, yes, there needs to be legislation specific to this instead of separate acts here and there, both at federal and state levels that are all varying. Honestly, that gives powers to law enforcement, it gives powers to government agencies and international to act. And you've seen that obviously the reason you're highlighting the terrorism example is because that's worked. That legislation has given powers to the people that need it in order to protect Australians. And I think that's a very good way of looking at this. And I think child sexual exploitation should be treated in the same vein. This is an international borderless crime that we're dealing with international syndicates in some cases, right down to, the guy living next door. And there needs to be robust federal legislation that is recognised down at state level and enforced at state level, similar to terrorism legislation, and give those powers to law enforcement to act to protect children, not only Australian children, but children in these vulnerable countries that our citizens are committing these crimes against.
Yeah, you make that point quite strongly in your submission about it being about non-citizens of Australia. Most of the victims are non-citizens of Australia, but you also make the point about this inconsistency with legislation at the state and federal level and different jurisdictions. We heard earlier that internationally there are challenges because some countries like Germany, for example, don't consider viewing of material as an offence. And there's different definitions of a child, for example. Can you give us an insight of how that impacts your work? Obviously, as a not-for-profit community organisation, you're able to kind of, I guess, bridge those differences. But those differences in legislation, both at domestically within Australia at different state jurisdictions, and then internationally with things as simple as definition of a child.
Right.
How do they affect the work that you're doing?
Correct. It's very difficult. I mean, and you bring in religion and culture into that as well with child marriage and all sorts of branches that it can go into. It's very, very difficult. And there's a lot of grey areas internationally, which you would think there shouldn't be because, we've had the rights of the child, through the UN for the last 60 years. And there's 160 countries have signed up to that. So you would think there would be a standardised across each. It's not. What can I say to that? Maybe some countries need to make that an issue, make that a point of global concern. Why isn't that being followed? It's very clear in the charter, in the rights of the child. It's very clear as to what each country should be doing and the age of a child and all those types of things are very clear. So why is there such ambiguity, as you say? I guess all I can say to that is my organisation, with the limited funding, the limited resources we have, we don't have time to address those issues or the resources or the funding to address those issues. We have to work within that space. And as you say, yeah, that makes it very, very difficult. Even here in Australia, when we see the Australian government come out and say, right, we recognise this as a huge issue and we think that having a national public accessible child sex offender register is the way to go. And we're committing money to it, $7.8 million to it, and we want to see it happen. But then as soon as we want to do it, we've now got to deal with every single state and territory government in Australia who all have their own state level laws in relation to this, and none of them are in alignment with the federal policy. So where's that going to go? What's going to happen with that $7.8 million? What's ever going to happen with that register? We've got disjointed registers around this country. Speak with the people that work on them. I have. They'll tell you first up that the state registers are not talking to the national one. It's still a problem that I was hearing 7 years ago. It's getting better, but the Ancor system, the way it's been run is atrocious. The Peter Warburton example I've given you, you know, I think it highlights that. But at state level, look, the law enforcement agencies are trying to do the best they can. They've formed JSETs, okay? So you've got your state level police forces that are tasked to work directly with the federal police, and that's all then linked in through the ACCCE. These are all great moves that we've, again, like I said right before at the start of this, these are great moves we've seen in the last 5 years. They didn't exist 5 years ago. So this is all great, but the law enforcement agencies need the legislation to back it up. I don't know how you're going to get a public register, or how the Australian government is going to get a public register in Australia if you can't direct the states to toe the line. This is why we say in our submission there needs to be a national statement made in relation to child sexual exploitation that's signed on by every single state and territory government as a policy, and then they can work within their parliaments to develop legislation that is unified. That's my suggestion, and I know that's no easy task. So please don't think I'm just throwing that one out there. It's I understand it's a very difficult process, but that's what needs to happen.
I'm starting to think perhaps if we treated this as a kind of a standalone legislative framework that's needed, that might make that task more manageable. But on the work that you do, which I recognise is incredibly important work, and thank you for that. If you had the resources available to you and the level of funding available to you, is there a role for not-for-profits, NGOs around the world to come together and really look at this issue of international definitions, international accordance with the rights of the child for signatory nations?
Yes, of course. Yeah. I understand what you're saying, and yes, that's needed. I think we highlight in our submission about the competition that exists between NGOs in trying to obtain funding to provide services, and it's counterproductive, and in the sense of operating in silos where intelligence is critical. And you know, as I can see in the list of people you're going to hear from, you're hearing from many law enforcement to this panel, and I think one of the highlights that you'll hear from law enforcement is about the management of intelligence. And if everyone's operating in silos and not sharing intelligence, then we're going to have gaps, and we want to close those gaps. So, it's all very well to point the finger at law enforcement and say they've been operating in silos and not sharing with NGOs or other agencies, but the same can be said for NGOs. And I've had these discussions, at high level with organisations like IJM, International Justice Mission, where we want to set up database where selected NGOs that have gone through a criteria process that law enforcement and government are willing to work with, where we can actually set up some sort of database where law enforcement can feed into it, whatever level of privacy is agreed upon as being necessary. And then those other NGOs can feed into that database, so that there is a sharing of intelligence. And but there's only a few NGOs that are offering these services legitimately around the world. So it's on the onus upon the government or law enforcement to do their homework on that and include the ones that are needed and worthy and in the right position to provide those services. So that would be my suggestion. It shouldn't be just an open blanket, because unfortunately not all NGOs are really geared towards this or have the capacity, to be honest. It's, as you highlighted earlier, it's quite a minefield. If you're operating in another country, you're in another legal jurisdiction, for a start, and you're not the authorities. You're an NGO. So there's a whole minefield to walk through with all that.
Just quickly on the question of funding, is there a particular pool of money that you apply for funding from that's specifically for the kind of work that you do?
No. We have volunteers that go through different government grant offers that come out regularly. Some relate to this, but more to do specifically with online. You know, we've helped with things like during the pandemic, which we haven't spoken about. I know we're talking about social media stuff before, but all those safety teams I spoke about before, all of those were working from home through the pandemic. 70% reduction in their efficiency during that time to process reports. It was a horrific time with what was going on, the reports that were coming in. And I don't want to get off the topic of what we were just talking about, sorry, but I wanted to just go back to that quickly because that was a big deal, and it just highlights the fragility of that system because thousands of reports were taking months to get processed by those social media companies. Sorry, I just had to go back to that. So, but sorry, what was your question before?
My question was the sources of funding for the kind of work that you do,
Sorry.
and
Yeah.
whether there is a specific fund for this kind of work that you can access. Obviously not.
No, it's not. I mean, like I said, we apply for I think we've applied for 3 government grants at federal level and we've never received one. One was through the Australian consulate in Bali. They have a local program there and we have an organisation, and we applied to be funded for one of our projects in Bali, and a vegetable garden program got it over us. So I don't know. That's there are grants out there that
Run
we
an
can apply
NGO
for.
as well. I feel all your pain.
Deputy Chair, do you mind if I hand over? Is that all right? We'll
Yes,
come back if
thank you
we
so much.
if we have the opportunity, Mr. Conahan.
Thank you.
Thank you, Chair. Glenn, thanks very much for your evidence today. And I just want to move away from the online issue. And I know you've done a great deal of work, and thank you for the work that you've done on the ground. I'm just looking at the report you've provided, and you've had the model involving the 3 pillars of action: community awareness and education, investigation and rescue and rehabilitation. And they're, if not all, predominantly over in third world countries or developing countries, correct?
Correct.
I've been on delegations to developing countries to scrutinise their law enforcement in terms of drugs coming into those countries and then coming into our country. And it'd be fair to say the poorer the country, the more corruption that you see. Does that transpose into child abuse material as well, whether there is corruption in terms of turning a blind eye to it, or in terms of actually facilitating it with lower level law enforcement on the ground in developing countries?
It's a great question, Pat. It's a great question. And unfortunately, yeah, we see corruption in these countries, and we have real life examples where corruption has affected the outcome of cases. It's a very difficult space to work in. You know, like I said earlier to Anne, you know, sometimes we just have to work within the goalposts. We just can't move them. I've had an example where we've had, you know, an Australian offender has paid money to the victim's family during the court process in order for the victim to withdraw their complaint, and the process finishes. You know, and then we've had examples right up to, you know, an example a few years back in the Philippines where a judge was paid a certain amount of money. And it was found out later on that the judge was paid money. He ended up going to jail, as far as I'm aware. But that's just, you know, examples of where corruption, and particularly at lower level, at police level, we've had examples where we may have worked with local police for 6 months on a case where we've provided maybe some surveillance services and other types of information intelligence gathering, and then we may have assisted those law enforcement agency to follow through their investigation, only to find when the law enforcement agency go to do their raid that morning that nobody's there, and usually you find out that somewhere lower down the ranks someone's received that information in the police and has sold that information to the target. So that happens, but I will say that also happens in Australia. I've been in law enforcement, you know, in Victoria Police for 13 years, and I've seen my fair share of corruption in Australia, both at law enforcement and government levels. So it's obviously I don't make light of that. the depth of corruptions in some of these other countries, obviously, is very different. But corruption is always a problem. It does assist and facilitate these crimes, particularly where we're talking organised crime. We're talking syndicates that are involved in trafficking of children and that type of thing. Then yeah, usually there is some involvement where they have payments or something going on at certain levels to facilitate those crimes. There is ample evidence of that.
And in terms of the answer, thank you for that answer, should I say, in terms of corruption, what about the acceptance of in culture and in community of those programs that you're trying to put through for the education and rehabilitation and protection of the children? How is that generally received in those poorer communities?
Yeah, quite well, believe it or not. You know, what we found is I'd consulted, as you would have seen in my submission, for a few different organisations prior to forming my own and worked in a few different countries and saw the approaches that some of these foreign NGOs were having. And I felt that there was too much Western thinking going on. I found that by interacting with these different cultures, that they have their own mechanisms and systems of managing society. And if we take the time to learn what they are, we can bring our message and use those existing systems, and they're going to be far more effective. What I found is very few NGOs and even government. I've had this discussion with the AFP in Bali. Very few government agencies do this either, where you actually go and consult with the local people, understand what the mechanisms are and how you can bring your message into that mechanism instead of coming over the top of it and trying to just bring in your message. And I think that's where we've really differed over, in our existence, where we spent a lot of time at ground level interacting. If we're talking, remote villages in Southeast Asia, and talking with their cultures and understanding how it works. So to answer your question, in that process, we held many community awareness meetings where village leaders, respected elders would invite the community to come. And in most cases, we'd have over 100 participants at a time. We ran over 80 of these meetings. And, we would give a short 40-minute presentation and then we would hand it over to the floor. And that would usually go for over an hour. And some of it was quite emotional. There were people in those communities that had been willing and wanting to talk about this problem for decades. Some very, very emotional stories came out. But what was very clear is that those communities do not condone these crimes. It's just that, like it has been in Australia for so long, swept under the carpet. This is why we've had, what you've seen, the, Royal Commission into child sex abuse in institutions. Look at what's coming out. Generations of child sexual abuse in Australia that has been ignored. And I don't need to harp on about it. I'm sure you're aware of it, and that's still coming out. So and that's here in Australia, and we're a developed country. So, but none of us stand for it. Yet nothing was getting done for decades. And that is exactly the same in these communities. Nobody stands for it. And but most of them don't know where to go. Adding to it, a lot of these cultures have that not wanting to cause a scene in their village, not wanting to lose face, not wanting to be shamed. These types of things restrict the reporting of it. We believe for every report you see at village level, there'd be at least 10 to 20 more that aren't. So, and Australian statistics show that only 20% of these crimes are ever reported in Australia.
Just in terms of the education and bringing it back on shore, have you had any exposure to or looked at the remote Indigenous communities for exploitation of children there?
Only briefly. I did come up to Darwin and spent some time up there back in February 2019. And I met with a number of government agencies up there. Happy to provide that information to you outside of this, if you require.
That would be great. Thank you.
And there was some initial interest expressed in our Sentinel model program, where some of the aspects of our pillars would be appropriate. And that's the idea of our Sentinel model. It's designed to be tailored to individual communities and work within their communities at grassroots level. So we presented our model to them, and there was a number of Services Australia and a couple of others that were quite interested. but it never went anywhere, I'll be honest with you. And we haven't followed it through. So and this is part of our problem too, is that we're very, minimally resourced, with very little funds, very little resourcing compared to some of the other large organisations that you see in Australia. I mean, we have a 20th of the budget of a Bravehearts or a Daniel Morecambe Foundation but we're not trying to be one of those organisations. They provide some fantastic services in Australia that we could not provide. We do not have the capacity to provide those sort of things. So we try to provide, the services we can in the gaps and have the best effect that we can with the very little resources and funding that we have.
Yeah. Thanks very much, Glenn. I appreciate it.
Thank you, Pat.
And thank you again. That brings us to the end of our time, but I really appreciate you being so forthcoming with the committee, and thank you again for what PK is achieving and your dedication to the work.
Thank you, Julian. And
thank you very much.
Thank you to the committee for... sorry, Pat.
Sorry, before you sign off there, Chair, do we need to give a date to that information or allocate a date to that additional information that Glenn
well, look, I'm sure Glenn will provide it as soon as possible, but when we wrap things up, we'll do a formal motion at the end of
Thank you.
the 2 days of hearings and provide you with a formal date.
Just to confirm it, you want the information in relation to who we spoke with, who we met with up in Darwin back in 2019? Yep.
Yeah, in terms of looking at Indigenous communities, remote Indigenous communities. Thank you.
Thank you. Okay, I'd just like to say thank you very much to the panel. Thank you, Julian, and thank you for accepting our submission and inviting me to come and speak and give more detail on it today. And thank you very much for your time and your insightful questions. I hope I've been able to give some more information that's helpful. But thank you very much for including us in your inquiry.
Great, thank you very much. The committee will now take a break and come back in an hour on the hour. Thanks very much. Wait. Hi, and I'll just do some formalities. I remind committee members and officers that the Senate has resolved that an officer of a department of the Commonwealth or of a state should not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Ms. Welch, I'll also remind you that it's a public hearing, so everything that you say will be broadcast. If you'd like to provide confidential evidence, you're quite welcome to. Just give me a heads up so that we can turn off the broadcast. We have a copy of your submission, of course, and in a second I'll hand over to you for a brief introductory statement. You got myself as the chair, Julian Simmons. You've got Dr. Anne Lee on the line as the deputy chair, Pat Conahan, and also Senator McLaughlin on the line from the committee. If you would please state your full name and the capacity in which you appear before this hearing for the record.
Good afternoon, Chair and committee members. Thank you for the opportunity to come along and speak before you today. I'm attending today from the lands of the Wurundjeri people and I wish to acknowledge them as traditional owners. I would also like to pay my respects to their elders, past and present, and Aboriginal elders of other communities who may be attending the hearing today. I am the Detective Superintendent in charge of the Cybercrime Division, the Crime Command of Victoria Police. The division includes the Joint Anti-Child Exploitation Team, referred to as the JACET, which provides a combined Victoria Police and Australian Federal Police investigation response to online child exploitation. The activities of the JACET include victim identification in child abuse material, which I will refer to going forward as CAM, identification and recovery or rescue of vulnerable children from further harm, the online monitoring, investigation of offenders and liaising with interstate and international law enforcement agencies to facilitate a coordinated response to this offending. The global scourge of online sexual exploitation of children is growing. It's enabled by technology, and these offenders are consistently developing new and innovative ways to access children and images of children, motivated primarily by the pursuit of sexual gratification. As the viewing of these images becomes normalised and sexual arousal is more difficult to achieve, offenders often search for more graphic depictions of depravity involving sexualised violence and torture of children of all ages. As demands for new images grow, this increases risk to children as offenders seek to create new cam, satisfying the demand. More recently, investigators have identified a growing trend in self-generated cam. This can involve children producing cam in response to being groomed by offenders they meet online, and other situations where children are otherwise manipulated into generating cam for the edification of an online offender who is threatening to expose the child to family, friends, or the broader online community. The online sexual exploitation of children is also enabled to some degree by the reticence of the community to discuss these crimes openly, as they would with other crimes that harm, such as drug crime. This limits broad awareness and the ability to educate the community about risk and how best to support children to engage with technology in safe and productive ways. Ensuring the right to privacy, free speech and anonymity online all impact on children's safety. The exercise of balancing human rights is consequential for children, and the decision society must make about how and when platform providers should be held accountable for the services they provide. The world of child exploitation online is fast moving, as fast as the growth and sophistication of the technology that enables it. Technology is increasingly enabling offenders anonymity, agility and ability to obfuscate. Technology is also very receptive to the innovation of the user, who can push and pull it to their advantage. Gaming platforms, social media platforms and other such communication enablers are perfect havens for offenders to prey on children. The recent COVID-19 pandemic only exacerbated risk to children online as they were driven indoors in front of computer screens, with social media and various communication platforms the most popular method of engagement with friends in the outside world. A systems approach, I submit, is required to reduce harm to children online. For example, we need to broaden community awareness about the extent of the problem, so the ever-increasing harm to children enabled by technology is high profile, much like the awareness campaigns for drugs, alcohol, seatbelts, speeding and the pandemic response. Services can be provided to enable offenders and possible offenders to seek help and support to avoid further or future offending. Highly capable, well-resourced and flexible law enforcement will complement these measures. Success in responding to online child exploitation is likely or may be evident through frequent open conversations in the home about online risk, assistance and support to those who self-report sexual feelings towards children. Reduced vectors for offending for criminals is crucial. They may be achieved through greater regulation and oversight by platform providers and greater online police presence, both overt and covert. Police measure success, our own success, in various ways. Firstly, and perhaps foremost, the number of children removed from harm is often identified as the key measure of success in the first instance. This is stopping the harm one child at a time. When we talk about rescuing children, we mean removing children from the reach of contact offenders in the first instance. An increase in the number of offenders identified, charged and successfully prosecuted is also highly sought after. A reduction in the instances of CAM offences and the creation of a hostile online environment for child sex offenders. We need to wrestle with the conflicting human rights which occupy
Whoa, what's going on there, Sean?
Sorry, we're just going to see what we can do to fix that problem now. If you just give us a...
Some kind of gremlin in the system.
Like an echo.
I think what's happened is I've got sound on my computer, so I might just hang up my phone.
It's not just an echo, it's a repetition.
Yeah, weird.
Can you hear me?
Whoa, yep. Whoa, yep. Good.
Fantastic, fantastic. I've just turned my phone off, so that should stop that gremlin. Can you still hear me?
Sure can. Please proceed.
Fantastic. Okay, that means I can turn my video on.
Chair, can you hear me? Sorry, it's Sean here. Ms. Welsh, can you turn either your phone or your computer off? I think if you've got both on, that's what's creating the echo.
I've turned my phone off, so the echo should be gone. Is that right?
I'm just going to check with my colleagues in broadcasting. Do you have a headset available?
I can get someone to bring one to me. Yeah.
Yeah, I mean, the problem here seems to have been fixed. But Ms. Welsh has turned her audio off, so perhaps that's helped resolve it.
It might be.
Are we getting feedback now that I've turned it back on?
No, that sounds great.
How does that sound? Okay. If that's satisfactory, I'll keep moving. If someone would like to indicate that that's all okay.
Yes, that's fine. Please proceed.
We need to wrestle with conflicting human rights which occupy a central position in the existence of online child sexual decisions necessary to reduce harm.
This is off, right? You're not off, Sean. Persevere, Ms. Welsh.
Thank you. These include the rights of children and the right to free speech, most particularly anonymous speech. How does a society ensure that all possible is done to understand what the right balance is, how to achieve it, and how do we know when it's achieved? It would be of assistance to have a clear position on the balance between these human rights, which articulates parameters for, but also proactively supports law enforcement interventions against those who harm children. The Victoria Police submission in this inquiry identifies factors that, if addressed, might enable a more effective law enforcement response. These include better understanding of offender motivations, which is critical in reducing harm, and this requires ongoing research. Police require sufficient resources to meet the challenges presented by modern technology, such as encryption, which enable offending, including contemporary information technology and hardware and software, which allows covert access to offenders' computers and communication devices to more effectively collect and seize digital evidence, identifying offenders and children at risk. Timely access to digital evidence is a vital component of effective law enforcement. Police also need specialist capabilities to be more effective, for example, victim identification experts and covert online operatives. Easier access to Commonwealth legislation which supports covert online investigations is also critical. Victim identification capabilities, which is a unique specialty area in the policing of this offending, It supports our primary measure of success, which is the removal of children from harm. Investigators in this area require specific training and skills, and the outcomes in this area are dependent on healthy and active global law enforcement collaboration. Digital evidence is also a critical component of successful policing in this area. Access to digital evidence is crucial in the production of a strong policing response to online child exploitation. Access needs to span the big communication platforms through to the single device used by an individual offender. Access to digital evidence can be supported by strong government interventions, be they law, regulations, or influence at a policy level. Ongoing training for police investigators and specialists and technology, both hardware and software, to support police investigations. These investigations are also supported by maintenance of really quite complex covert IT networks, which must be supported by specialists in that field. Reducing waiting times for digital evidence for communication platforms is also critical, and I note that the pending Act has been raised in a number of submissions to the inquiry and showing all signs of a significant step forward in this area. And we certainly here look forward to realising the benefits that it promises if wait times are reduced in this particular area. So I thank you for the opportunity to speak, and I most certainly welcome any questions.
Thank you very much.
Thank you very much.
We're still getting that feedback, so I'm going to hand to Sean. Sean, is there any remedial action?
Sorry, we're going to ask Ms. Welsh if she can dial back in, because we don't seem to be able to resolve the echo.
Sure.
Thank you for that opening introduction. Can I take the first few questions to ask you about some of the trends that you may or may not be seeing in your investigations to help the committee prioritise what to look through? Some of the things that you mentioned in your submission, deepfake technology. How much are you seeing of it? Is it a small but growing trend, and how is it being utilised to deliver CAM?
So here in Victoria, we are not seeing high instances of deep fake. We are seeing, what we're seeing more of here are instances of what's been described as capping, where offenders are accessing sexual video content from individual social media platforms or webcams. We are certainly seeing that more.
Okay, so just explain that to us. So people are recording it for their webcam, and it's being taken, the material, or it's a version of spyware, or it's just a...
No, it's the capture and recording of self-generated sexual video content from an individual social media platform. So that can be accessed via different means. So, for example, from a Facebook platform, that might be some levels of deception may be used to access a person's Facebook account, and then the images are accessed and captured that way, and then redistributed elsewhere.
Okay, so people are loading this up knowing, they haven't been tricked into it. They've produced the material and uploaded it, but
Right.
with the purpose of giving it only to their select group of their select network, and people are trawling through those accounts to kind of hoover it up.
That's right.
Okay, all right, and is that kind of behaviour or that kind of offending in response to anything? Is that they're just finding that an easier way of getting material than trying to produce it in third party countries, or is just a new way of offending?
I think it's mostly the latter. These offenders are constantly looking for new vectors to access this type of material. So I think that this is just another way for them to access it. The instances of self-generated TAM is also something that is raised concern. We're seeing a lot more of this from young people. So this is also where they are groomed, often the result of grooming, and they are coerced into generating this material. And once that is generated, then they are very easily to manipulate for the further generation of their own or accessing other children to generate further child abuse material.
They're blackmailed essentially into producing more material.
Very simply put, yes, they're threatened.
Can I ask you? We might circle back to that, but just on other trends that you're seeing, some of our other witnesses have raised an increase in the use of cryptocurrency. Are you seeing cryptocurrency being used more in the payment to procure CSM, and is this method of payment present different challenges to what investigators are used to?
I understand that cryptocurrency is being seen more in the payment for child abuse material. Now, whether that be, it comes in many different forms, and I'm quite sure the committee realises that the complexity is ever increasing. So it may be the use of a cryptocurrency to access a child abuse forum in the first instance, or it may be the use of cryptocurrency to access live abuse of children in a pay-to-view type situation, or it may be the use of cryptocurrency simply to buy CAM that particular person wishes to add to their collection. They are some of the ways that cryptocurrency can be used. And in response to your second question, yes, the use of cryptocurrency absolutely adds a layer of complexity for law enforcement.
Can you just explain that to me a little bit more? So, not in a situation where money actually, or wouldn't actually be changing hands, it'd be an electronic transfer. You'd be able to request from a bank as a law enforcement agency to get access to who owns that account. But what the practicalities are is there isn't an institution to go to for this Bitcoin. It's traded privately.
Yes, it's traded privately. It's unregulated, and it's a very easy way to transfer. Let's call it to transfer money and payment, particularly if it's not used with Bitcoin, which has a public blockchain. Some of these other cryptocurrencies do not have such a public blockchain.
There's talk at the moment of public institutions, even up to the RBA, regulating cryptocurrency and becoming involved. Do you think that will aid law enforcement if people are then keeping it in more regular financial institutions, or offenders simply won't keep it in a bank in any case?
No, look, I think the regulation of cryptocurrencies will be helpful in many different areas, not just for law enforcement. But as long as cryptocurrency can be exchanged from peer to peer, it will make it extremely difficult.
Have other jurisdictions tried to tackle that peer-to-peer transfer in relation to this issue, or it's just something that where the technology is ahead of us at the moment?
So the answer to your first question is all jurisdictions are trying to tackle this, and we tend to stand at each other's shoulder as often as we can so we're not duplicating effort. So this is being worked on across the country and across the globe, quite frankly, about how we deal with these sorts of exchanges peer to peer.
Okay. Can I ask you about something else in the committee's terms of reference, and that's the use of remote access Trojans? Are you in this, you're talking about people trawling others' Facebook accounts before. Are you seeing much instances of people installing spyware and using that to access either people's private photos and materials, or turning on a webcam and producing cam that way?
Not so much here through the jacket. I think those sorts of activities by offenders are seen in the family violence space, but here in Victoria we are not seeing that as commonly here in the context of CAM.
Okay, no, that's fine. That's good. Can I ask you then about some of the points specifically in your submission? Your point about needing AFP buy-in to access Commonwealth powers, and obviously I'll ask this of the AFP as well, but reasons why they might not be willing to do that in all cases, whether it be resourcing priorities or I think the other thing that your submission mentioned is that they carry then some risk within the operation. Is there a way legislatively to fix that so that with their approval but without resources you can then access Commonwealth powers and just have any Commonwealth offences you uncover referred back to them? Or is it less about legislation and more about the practicalities of working together as two organisations?
I think it's a bit of both, unsurprisingly. As this particular type of crime does not stop at state borders, and it is extremely fast moving, particularly if we have reports that come in and we need to action them immediately. It becomes very difficult to instantly stand up these teams across both law enforcement agencies. So that's one challenge. The other is, I think that it can be assisted by way of just very slight legislative reform that either minimises some of the friction in the access to the Commonwealth legislation, or in relation to the state-based legislation, it allows us in certain circumstances to operate outside Victorian borders. Because many times when we're working that way, we may not have the information that we need to fulfil the requirements of the state-based legislation. So I think that legislative reform would be extremely helpful in both those areas.
Look, I don't expect you to produce it now, but do you think you could take that on notice with you and point us at the committee in the right direction of that legislation and what kind of changes will be required from a practical sense?
Of course, yes.
Thank you. I'm interested in your experience with Facebook and other tech companies, particularly as opposed to the AFP, because the AFP and the Safety Commissioner, the feedback we get from them is that they tend to find particularly the big tech companies relatively responsive, but you've given us examples in your submission where it's taken a lot longer. I think your quote was anywhere between 4 months and 2 years. And so do you think that level of cooperation from big tech just isn't floating down to individual jurisdictions?
I do think so, yes. And I think that we are well past the point where we can rely on individual relationships between investigators and people in these tech companies. I think there needs to be a broader attention to this so that the companies are more responsive at a state and territory level as well.
When you talk to your other state counterparts, are they experiencing similar response times?
Yes.
Okay. Is it possible for you to give the committee again? Please take this on notice, but a couple of examples of longer wait times or inappropriate responses. Obviously, that just helps us when we confront this issue with the tech companies, who usually tell us that they're fixing everything very quickly.
Yes, I can.
Okay, that'd be great. Do you work closely with the E-Safety Commissioner to try and lean on these tech companies as part of your investigation?
At the investigative level, that's not where the pressure comes. The investigators at the level of a jacket, for example, are very busy doing the practical work. I think this leaning with absolutely all due respect needs to be happening above the level of the individual jacket units. They can most certainly provide the information and identify pain points. But the sort of leverage I think that you're talking about, that influence and persuasion needs to come from a much higher level than that.
Okay. It would also be helpful, again, reading through your submissions, if you wouldn't mind providing more detail about some of those delays with Commonwealth agencies as well. You've mentioned it broadly, but I would certainly hope that the committee, if you're able to give us some specific examples, that would be something that we could recommend. They were far more responsive to you, regardless of whether the AFP has buy-in in an investigation or not.
Thank you.
Can I ask you then about the other trend that we were looking at is beyond tech companies? Is there enough legislative and regulatory focus on cloud providers, cloud hosting providers? So as a way of offenders to store a large amount of CAN material and then delete it just as quickly as investigators are walking through the door. Is there a greater response that we need to recommend, whether it be encouraging cloud providers to do proactive searches or engage with law enforcement more? What's your experience there been?
This is an increasing problem for law enforcement, and that's access to the cloud. That's law that supports our timely access to data on the cloud, and also the responsibilities of the service providers to step into that space as well.
Okay, so it is an ongoing challenge. Is there anything that the Google and Apple of the world, how are they versus Facebook and social media companies to deal with?
Oh, I'm not sure. I'm in a position to compare and contrast on that one, but I can certainly get back to you with that.
Okay. No, quite all right. It's another area that the committee's very interested in. And then look, finally, before I hand over to the Deputy Chair, one last line of questioning. We've heard from a number of witnesses today about the potential for harm minimisation programs. They've likened it to harm minimisation for drug offenders. The committee has some significant concerns around that, about destigmatising this significant offending and the like. But do you have a view on whether there is merit in programs that anonymously try and get people to do some form of harm minimisation program before their offending escalates?
I think there's merit in exploring the possibility that it may be helpful. And I know that sounds somewhat obtuse, but I think that I don't think we should leave any stone unturned. And I think that there should be efforts to find out whether it is possible for us to explore harm minimisation that way.
Is your experience with offenders that their escalation can be prevented, or is, in your experience, is escalation not inevitable but part and parcel?
I just don't think I'm in a position to answer that one.
Quite all right. No, you're well within your rise to say so. Look, what I might do is, because of our shortened time, I've got a few more questions, but I'll hand over to the Deputy Chair now, and we can always circle back if time permits.
Thank you, Chair. I won't take too much time of the questioning, considering Detective Superintendent, you gave quite a comprehensive submission and quite a comprehensive opening statement. And in the interests of time, to give others an opportunity as well. But I did want to ask a question about, as we've had different witnesses today, it's really what has stood out for me is that the different aspects to this offending. You have grooming, you have viewing material, you have accessing material, you have producing material. You also mentioned self-generated cam by children who have been groomed or are blackmailed. There are so many different aspects to offending. It's not just a simple matter of viewing or accessing material. There's a whole range of other ones. Do you consider that the current legislation under which you operate is broad enough to capture all of those aspects of offending?
No, it's not broad enough to capture all aspects. And I think that the second component of my response to this question is, and it's difficult because of the complexity of the offending and the increasing complexity of the offending. I mean, we spoke very briefly earlier about deep fakes, which is different again, and technology that's on the horizon and technology that we have not yet anticipated. I think it will be of growing concern about how do we craft legislation that deals with such a rapidly evolving and complex crime type. I think that calls upon us all to think about how we might do this in a different way, perhaps.
Do you think that a suite of kind of standalone legislation that is specifically about CAM would improve the situation? Like currently we have a suite of standalone legislation for terrorism offences, for example, that range from everything from, accessing, producing material, publishing material, right through to, in travelling overseas. Do you think that we lack a kind of a comprehensive or cohesive framework of standalone legislation to deal with CAM and offending?
We do lack that. Consistent, coherent, and something that stretches across the country. So Federation also makes things very, very tricky when law enforcement is trying to deal with offending that crosses borders nationally and internationally. So that has been a particularly challenging problem for law enforcement, is the lack of definitions. Consistent definitions is also difficult. And so I think that what you're suggesting may go some way to traverse that tough ground.
Is the lack of definitions domestic as well as international? We know that internationally, for example, the definition of a child, some jurisdictions don't consider viewing as an offence. Is the lack of definitions also a problem within Australia?
I don't think, although I can certainly get back to you on this, I don't think that we have consistent definitions across Australia either. Just how the degree of divergence across jurisdictions, I'm less certain about, but I can certainly get back to you about that.
Thank you so much, Detective Superintendent, and thank you, Chair. I think I'll allow other people to ask some questions now. Much appreciated.
Thanks, Deputy Chair. I'll hand over to Pat Conahan.
Thanks, Chair, and thank you, Detective Superintendent. I'll just follow on from what the Deputy Chair was talking about, and that's the consistency of language in legislation. I can't find exactly where it was in your report, but you see that as a major issue between the states and territories. Is that correct?
It's an issue insofar as the move, it's important, we consider it important to move away from language that talks about child pornography.
Right.
Because this, and a lot of that is to do with messaging to community and also ensuring that this is always understood to be sexual offending against children. It's not pornography.
Okay. All right. I understand that, and I think the community as a whole is moving towards that and using the term child exploitation rather than pornography. So if I was to suggest that the consistency of language, with the exception of child exploitation, I'm talking about within legislation, cross-border, let's say cross-border operations or cross-border offending. Have you come across any situations where the language or the description or the definition within legislation has been such that a prosecution may fail because of the differences in the language of the legislation or definition?
I can't answer that immediately, but I can certainly get you some information to respond to that question.
Okay, thank you. The other thing that jumped out at me, and this is coming from an ex-police officer, so it's coming from the right place. Page 5 down the bottom, ensuring offences are prosecutable and holding offenders to account. And you say there, right at the bottom, that offenders are held to account through appropriate sentencing. Is that a very nice way of saying you are not of the view that the generally offenders are being given appropriate sentences in Victoria or across the nation?
No. I think in that submission there, it's an assertion that that offenders, when they are held to account by the court, that appropriate sentences are administered, not that they are not being.
Have you seen over the past, say, decade, with the proliferation of this type of material, the sentencing indicators reduced in terms of what people are receiving?
Are you suggesting are the sentences less than they have been in the past?
Yes, that's a better way of putting it. Thank you.
No, I haven't made that observation, but I think that would be a really simple one to identify simply by way of some data.
Yeah. Okay. Well, that's all I have. Thank you, Chair. Thank you, Detective.
Thanks very much, Pat. The other two members on the line, Senator McLaughlin and Senator Antic, have indicated they don't have any further questions. So well done, Ms. Walsh. Thank you for burning through them. Can I just take the opportunity then, with the extra time that we have, just to ask a little bit more detail about where you've struggled with Commonwealth agencies to access information in a timely manner? Can you just talk us through what your process would be there and where you think it's falling down?
The process at the moment is quite convoluted. We have to go through the Attorney General to get evidence that will be deemed admissible evidence in front of before the court. So it's not to say that we can access law enforcement to law enforcement, but if we wish to use that evidence in court as admissible evidence, it needs to follow a particular course. So the mutual assistance request, for example, the process is convoluted and it is competing. It's in a very small pipe is probably the easiest way to put it, competing with many other requests in relation to many other areas of law enforcement. So it is incredibly cumbersome and time-consuming, and it's not unheard of for us to have a person before the court and the matter's finalised, and then shortly after we might receive information back via a mutual assistance request.
Right. So you think it's a resourcing issue within, who are you writing to? The Attorney General's Department, did you say, or you write directly to the Commonwealth agency responsible?
Or now we're going through to the Commonwealth Agency. I don't know that it is a resourcing. I don't think it is about resourcing. I think the Cloud Act will do a lot to circumvent the challenges that we've had in many regards. But I'm not so sure if it is a resourcing thing. Throwing more people at it probably might not be the answer.
Yeah.
I think it might be a way of finding a more streamlined process and dedicating resources to it as opposed to throwing more in that direction.
Okay. Can I, sorry to jump around topics, it's just the way with these things. Can I take you back to the conversation that we were having before about the prevalence of capping, you called it, where but in particular where kids are encouraged to produce their own material, perhaps not realising what they're producing. The Deputy Chair quite rightly was raising it before with other witnesses. Are you seeing this happen more in gaming discussions, Discord and the like amongst those chat groups in terms of grooming?
No, we're not seeing it more in the gaming platform. We're not seeing it specifically, but the investigators are most certainly seeing more instances of self-produced child abuse material in and amongst the investigation that they're dealing with across the board.
Well, I guess if it's not gaming, then I guess what I'm getting at is how are they engaging with these kids? Is it just via Facebook Messenger? Are they friending them and then jumping on their direct chats?
Quite often, yes.
Right. Okay. All right. And the other witnesses that we've heard from today, we've heard a couple of witnesses from academia, and they spoke about their desire to do more research and to get more information. How do you have any thoughts on how we might improve the connection and flow of information between law enforcement, NGOs, and academics on this topic?
I think it needs to be a priority for law enforcement agencies and the areas within which these sorts of crimes are being investigated. Victoria Police does very well in this regard. We are in the midst of a very large research project with universities at the moment. So this is an area that is really critically important. I see that the committee understands that already. So it needs to be embraced by the agencies, and so when academics approach us and ask us for access to data and so on and so forth, be that qualitative or quantitative, the agencies, law enforcement, is to be very receptive to that, because it's an incredibly important tool in relation to us understanding how best to deploy our resources towards this offending.
So we could perhaps the way to go about it is for the Commonwealth and other law enforcement jurisdictions to lead the way in terms of opening up information for this kind of work. I agree, it is critically important. Look, thank you very much. You've been very forthcoming. That answers my questions. Deputy Chair, before we allow the witness to depart, have you got one more?
Yeah, thanks, Chair. I just wanted to ask very quickly around the Slade legislation, the Slade bill, and whether that's had any flow-on impact to VicPol being able to, I guess, identify and prosecute offenders.
Slade legislation is relatively new, and I anticipate that it will make a a significant impact, not just on this area, but on the investigation of crimes much more broadly, for example, serious and organised crime.
But you haven't seen the flow on yet?
Not yet, no.
Thank you. Thank you, Chair.
No problem at all, Deputy Chair. Thank you very much, Detective Superintendent. We really appreciate your time today and giving us the value of the experiences with VicPol. And again, thank you so much for persevering with those technical difficulties. We apologise for that.
That's my great pleasure. Thank you all very much.
Thank you for your help. All right, we've got Alex and Toby on the line. No point delaying if they're both here.
Chair, we are both here.
Hello.
Hello. A little bit of formalities. I remind committee members and officers that the Senate has resolved that an officer of a Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy, does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Gentlemen, you've got on the line myself as the chair of the committee. You've got Deputy Chair Dr. Anna Lee coming to you from WA. You've got Pat Conahan. And then you have on the line Senator Andrew McLaughlin and Senator Alex Antic, who can hear you and ask questions, but you don't have the video capacity. Can I get you both to state your name and your position for the Hansard record for me, please?
Thank you, Chair. Toby Dagg, Executive Manager, Investigations at the E-Safety Commissioner.
And Alex Ash, Manager, Online Content at the E-Safety Commissioner.
Lovely. Right, well, we've got your submission, which we appreciate, and we hear from you regularly, which we appreciate even more on various inquiries. But does anybody want to make an opening statement to draw anything to the committee's attention? Toby, you look like you're itching to go.
Oh, no, Chair, I was actually going to say that in the interests of time and the committee's time, we'll forego the opening statement. Everything that we wanted to express and explain is contained largely in our submission. Okay,
look, that's very, very kind of you. All right, well, I might kick off the questioning if the committee is happy. Can I take you to the stat that 30% of all image-based abuse reports are from Australians under the age of 18 through your own information? Can we just get a feel for the increase in volume of this, or as a percentage, are you seeing an increase in under 18s versus over 18s in the production of IBA?
Thanks, Chair. Interestingly, that statistic as an expression of all reports that we receive has remained fairly static over the fairly short time that the image-based abuse scheme has been in operation. We've only had the civil penalties scheme in place since October 2018, so we're still working with only a scant few years of data. But generally speaking, 25 to 30% of our reports are made by under 18s. But overall, the number of reports made to us by Australians has increased, and that was particularly acute through the COVID period last year, where 2020, when compared with 2019, saw a 114% increase in image-based abuse reports made to the Safety Commissioner.
Okay, so you're seeing an overall increase, which we knew, but not necessarily a larger increase in CAM material as opposed to over 18.
That's correct.
As a percentage. So you request the removal of the IBA. What percentage are you successful in taking down? I think I saw a figure of about 80%, or is that fair?
That's right. It's about 80 to 85% of material is successfully removed based on our informal request. And as we may have explained in the submission, our preference is to work informally where we can. We find that is a rapid and efficient way of removing material, and perhaps somewhat counterintuitively, even those sites that create their business model around distributing image-based abuse material, when they're approached by the E-Safety Commissioner, often take quite rapid removal action, even in the absence of a formal removal notice. But we have used our formal tools in the past.
So those 15% or to 20%, they go to a formal notice, do they? Is that, yes.
So will consideration to issuing a removal notice against the service or against the perpetrator will, if it is the case that a young person has been involved in the distribution of material without consent, we'll generally try and work through an escalation process. So we'll issue a warning to that young person. We've had great success working with schools as well. We're very keen to become involved where there have been image-based abuse matters that concern their students. And for the most part, they seem to be fairly effective tools when it comes to adults involved in image-based abuse. As between adults, we have had recourse to more extensive remedial notices requiring people to do things to prevent a continuation of the prohibition against sharing image-based abuse.
Can I ask you about your safety by design approach? Because I know a lot of your efforts go into, or a significant amount of your efforts go into that, and it's incredibly admirable. But you know, we are seeing this rapid explosion of CAM. So you know, I'm wondering how successful we're really being putting it back on industry to do safety by design, and I'm wondering if in your discussions with other jurisdictions and the like, you know, there's any examples or experiences that are leading you to form the view that this safety by design stuff needs a bit of legislative or regulatory heft behind it if companies aren't going to take it up voluntarily.
Yeah, thanks, Joe. I think we've seen a much greater engagement from industry with the principles behind safety by design. As you will know, we recently launched some extensive tools that allow industry to assess their safety posture according to best practice, pitched at both startups and more mature companies. And we could not have produced those tools without the input of industry. So those tools were the product of consultation with hundreds of industry players. They were very much tools made for industry with the assistance of industry. And we have seen some real innovations in these areas. Some of the platforms, for example, are making it impossible for users to search out young people and children, making their platforms hardened against adults who aren't connected to the child or young person through existing networks, actually discovering them on the platform, which is very welcome. But we acknowledge as well that there's a long way to go overall, because when we talk about industry, we're really talking about a staggering variety of industry sectors, everything from ISPs through to hosting services, social media services. Some of those sectors are more advanced than others, and others within those sectors are better at adopting safety by design as an approach than others. In terms of the legislative connection, you'll be aware that consultation recently finished on a set of basic online safety expectations, which are a really important part of the Online Safety Act, which will require companies to provide reporting to the Safety Commissioner in relation to a range of safety issues. They have been devised very much with safety by design in mind. So you can see the sorts of principles that are central to safety by design expressed through the basic online safety expectations. So we already have a legislative hook to require the giving of insights from industry about how they're approaching safety as a component of their design process once that instrument becomes operative under the Online Safety Act.
And is it those struggling with, those who are not struggling, those who are less likely to throw their arms around safety by design, are they the smaller platforms who don't have the resources, or counterintuitively is it the larger ones who are trying to work backwards to kind of incorporate those principles long after the horse is bolted?
I think it's definitely both cases, Chair.
Right.
The reason why we created two separate assessment approaches was to accommodate for startups who, naturally with a very small staffing complement and limited resources are trying to get a product to market as quickly as possible. And if experience watching that process unfold is to us anything, that safety sometimes gets considered last, if at all. And so that's why we're very much of the view that, embedding a safety trust culture within companies is really essential. And the safety by design framework accommodates for that. Similarly, platforms where they brought products to market, very advanced platforms, well-resourced, very sophisticated. The product lands in the marketplace without any thought given necessarily to the safety of children using the product, it is often the case that requires a retrofit. And that's something that we do encourage companies to invest in as well.
So how much emphasis do you think we should be giving to encouraging companies to enforce more heavily their own standards that 13-year-olds shouldn't be on their platforms, for example? So, you know, some of our other witnesses have suggested that platforms be required to get parental ID or something like that to demonstrate parental consent for an under 13-year-old, versus pushing them to incorporate parental controls, which would allow, I guess, ongoing monitoring for parents beyond just whether or not they get on in the first place.
We would certainly like to see much more extensive parental controls rolled into services and platforms, particularly those that are designed with children in mind. I think we've seen some real movement in some of the larger platforms over the course of the last 12 months or so to provide better tools for controlling what kind of content children are exposed to, and actually rolling out specific products for children which have more limited functionality and much greater ability for parents to observe the interactions that are occurring online. So the requirement as well to ensure that there is an age limit is something that we often are in conversation with platforms about, where we learn that a child or young person has been involved in any of the harms that we deal with, and they do present as under that age. We'll often bring that to the attention of the platform as well, because we do see that as absolutely a factor in contributing to a child's safety on the platform.
Sure, but I mean, there's tens of thousands, hundreds of thousands of kids under 13. I mean, they're clearly not that, or to date, they haven't been that enthusiastic about enforcing their age limits. I mean, you can't speak for them, I get that, but what's been your experience? Is it just has been up until now a driver to get numbers on the platforms, and this has been an easy one to ignore? Is that changing, or do you think this is just something that's going to require a stick approach rather than a carrot?
Well, whether it applies a stick or a carrot is a question we'll leave to government, but I think the awareness of ensuring that the capacity of users to use the platform in a safe way is much more front of mind for industry than it has been in the past. And that's true for not just children, but other vulnerable groups using these technologies too. So certainly we've seen a much greater openness within our conversations with industry to discuss those factors as contributing to the overall net effect of user safety online.
Can I take you to a part in your submission where you're talking about encryption, which we all wring our hands about a little bit, but you've got a sentence in there that says there are a number of solutions that would ensure illegal activity online can be addressed, and that's in relation to encryption. Can you expand on that? Because as I said, we've heard a lot from other witnesses and submissions about the dangers of encryption, but very little about how anyone can impact what seems to be an inevitable march of all of them encrypting their communications.
Sure, Chair, and I'll just preface this with a disclaimer that I'm no technical expert, so
yes.
If I can just tell you.
It's all right, neither are we. It's quite all right.
To be the case from some of the discussions that we've had with people who are technical experts, and I suppose that there are two possible solutions in particular that seem to be key to understanding some of the options that might be available to platforms that are moving towards an end-to-end encrypted model. Whether they're commercially viable or feasible is another matter, of course, but one of them is on-device hashing of media. We saw Apple introduce that feature earlier in the year, and there was some discussion about whether or not it was the most effective or feasible way of going about ensuring that some of its services weren't being misused for the purpose of sharing child sexual exploitation material. But there seems to be a view amongst some encryption experts that initial hashing of the media could happen on the device, and then the hash signature of that item of media, be it an image or a video, could travel along with the encrypted communication, so that could at least be shared with the likes of the National Centre for Missing and Exploited Children to identify accounts that are engaged in the distribution of child sexual exploitation material. There is another option, as we understand it, which is referred to as homomorphic encryption, which is a different form of encryption that, as I understand it, performs computation on already encrypted content to produce some insight into the kind of media and kind of content that is being shared within that encrypted communication. Beyond that, I'm not a cryptographer. Obviously, my technical knowledge of those areas is very limited. But as I understand it, they are two of the sort of more promising areas of mitigations that are being offered as possible alternatives to the current situation if platforms move to an end-to-end encrypted model.
If there is further information within your organisation from those technical people on those kind of solutions, we'd be very grateful to get it on notice if there was the opportunity for that.
Very happy to help where we can.
That'd be great. So we've spoken earlier in the day about the hashing technology, so it still wouldn't allow you to read those communications, probably not even identify the person, but you would pick up, I guess, if they shared a particular image that was already in the database, essentially.
That's what we understand. So if, for example, we take the first example of on-device hashing where the hash travels with the cipher text or the encrypted communication, if it was a violative hash that related to known material that was, say, for example, in the National Centre for Missing and Exploited Children's database, at least that account could be flagged with NCMEC. NCMEC would perform, the initial triage of the matter and then pass it on to law enforcement for further consideration. And law enforcement might, use its existing processes to obtain more information from the company about the account user.
Okay. All right. Okay. Can I take you to a few trends that the committee is interested in, and if you're not seeing them, that's as good information as if you are, but it will just help us focus our time. Are you seeing many instances of IBA produced by deepfake technology? So people basically manufacturing cam material that isn't real?
Not to any large extent, Chair, but it's something that we are preparing to see more of. So we're fortunate in that the existing legislation at this point is made particularly clear in the Online Safety Act, ready for when it commences on the 23rd of January, is that image-based abuse material is material that is or appears to be a particular person. So it accommodates for the potential growth in deepfake based reports, which we think is probably on the horizon.
Yeah, so are they seeing it in other jurisdictions overseas? Of I think particularly of revenge porn type instances where a broken down relationship among minors might result in that kind of stuff being produced.
We haven't heard any reports from our colleagues that, for example, the revenge porn hotline in the UK or our In Hope sister hotline in the IWF, what they're actually concerned about mostly is the rise of self-produced material rather than deepfake material.
Yeah, okay. And in terms of self-produced material, so we were just talking about this with the representatives of VicPol. How are you seeing that material being procured? Are they simply friending somebody on, what are the practicalities of it? I guess, are they friending somebody on Facebook and then just direct messaging them? Are they doing it via gaming chat portals? Where's the prevalence?
I'll hand over to Mr. Ash for some more information on that their question from the perspective of the online content team. But certainly when it comes to image-based abuse material that relates to under 18s, the sexual exploitation of children features in about 65% of our reports. And very often we see that the service that is most heavily implicated in some of those reports are Snapchat and Instagram. We've also seen instances of offenders frequenting Omegle, an online service which then allows them to connect randomly with young people online and move them to other services where they can further explore the conversation. But Alex, maybe you've got some insights from the online content.
Chair, I think all of the examples that you provided are examples that we see. So we see examples of, conversations where people start conversations on a platform and then they move off platform to procure child sexual abuse material. We see examples where of peer-to-peer sharing that then ends up in the hands of the people that it wasn't intended for originally, but also those instances where children are coerced into producing content that they, didn't want to, so they're blackmailed, often in their own home. We've seen videos where you can hear parents in the background having a conversation while the child's in the bathroom. So I think it's, all of those examples.
Are you seeing any examples of remote access Trojans being used? Spyware essentially for people trawling other people's photo collections and things like that remotely?
I don't think so in the online content side of things, potentially in IDA, Toby.
Not to any great extent, as far as I understand it, Chair. Certainly the potential risk for a device being compromised by that means is something that we talk to frontline staff working with domestic and family violence sector through our eSafety Women program. But in terms of content production, it's not a methodology that we see represented in our data to any great extent.
Okay. We heard as well from an NGO, and I'm not trying to be specific to that NGO, so let's just say NGOs in general, who might want to take on a more investigative role than the traditional NGO role of education and awareness. And I guess that NGOs playing in some kind of investigative role is, I don't know, more of a US kind of model that they see over there more. How do you engage with NGOs who might want to add capacity, I guess, from that point of view?
We work very closely with the Canadian Centre for Child Protection in Winnipeg. They don't perform an investigative function per se, but they certainly take reports from the public about child sexual exploitation material and pass information to law enforcement. We've worked with them very productively on sharing information about some of the trends that they're seeing and some of the issues that they are concerned about that are manifesting on social media, and using those insights as the basis for our own investigative activities, and have collaborated really productively with them, but also other members of the Canadian Centre is no longer a member of InHope, but we work very closely with our colleagues within InHope as well, along similar lines. Whether or not an NGO can or should be performing an investigative function is not something I'm probably best placed to comment on.
Okay. All right. Look, I might hand over to you, Deputy Chair, if that's all right. If you're ready to rock, and I can cover some more things at the end. Go ahead.
Thanks, Chair. I've got just a few questions, and I'll refer in your submission. You talk about the clear web, and basically that the assumption that it's something that's solely on the dark web is a false assumption, and that predominantly the material is on the clear web. The Uniting Church in their submission referred to a very interesting phenomenon here, and they referred to the sharing and the uploading of handbooks and manuals on how to entrap and groom children. And they refer to a couple of arrests, one in the UK and one in the US, of perpetrators who have been found in possession of these books, who have been found to be distributing these books or these manuals. Is that something that the eSafety Commission has come across? Does the tools and the imprimatur of the eSafety Commission extend to that, so that you have capacity to deal with this kind of material?
Thanks, Deputy Chair. I think the short answer to your last question is yes. So a handbook that would be providing instruction in grooming techniques, for example, would be almost certainly considered Class 1 content under the Online Safety Act, and we'd be able to issue a removal notice against that. We're just very careful about the dark web services like Tor, and not doing anything that would potentially compromise or prejudice a law enforcement operation there. So that goes to doing things like creating accounts, for example, and leaving a trail of our own traffic for when a service is rolled up and investigated by law enforcement. We certainly don't want to situation where we're going to have to deconflict after the fact. So we're very respectful of the fact that the dark web is largely where our law enforcement colleagues do some of their excellent work, particularly when it comes to identifying victims. In terms of the existence of handbooks and the like, probably a question, if I could respectfully suggest, best asked to the AFP. As we said in our submission, we are concentrating on the distribution of material at scale on the clear web, and we're really focusing on images and videos.
But you're not precluded from also removing textual information such as is included in a manual or a handbook.
Right, so that would be material that would likely be captured under the provisions relating to material inciting, instructing or promoting crime. Because if there is a handbook that provides practical guidance, it would certainly fall within the instructing subcategory of some of those content types.
Thank you. Is much of the material in the CAM material captured through the AVM Act? I mean, we had the review of it just a couple of weeks ago, and I believe you both appeared in that. Is much of the material captured through that Act?
Technically, the penetrative sexual abuse of a child could be considered under the rape definition set out under the AVM amendment. It's perpetrator produced material. It shows abhorrent violent conduct in the form of rape. So yes, it could, but we've found, Deputy Chair, that a far more effective and efficient, rapid way for us to deal with that content at scale, noting that we concluded about 14,500 regulatory investigations into child sexual exploitation material last financial year, is to leverage our relationship with the InHope network. And so about 13,700 odd matters were notified to InHope in the last financial year. About 74% of all of the material that InHope handles within an annual period is removed in about 3 days or less. And so last calendar year, 2020, the InHope network handled more than 1 million individual media related to child sexual exploitation material.
Okay. I want to go to this this problem of self-generated material by children who are either coerced or I think you also mentioned in here it could be a romantic relationship and then it becomes that. But the scheme that you have is the image-based abuse scheme that deals with that. Is that correct?
It could be dealt with arguably under both schemes, Chair. It depends on how the matter is brought to our attention. Through the online content scheme, we aren't working directly with victims or survivors. We're dealing with members of the public who very often anonymously report to us where child sexual exploitation material is provided on the Clear Web, on a website. And then through the image-based abuse scheme, of course, we're dealing with those who are directly affected by the non-consensual sharing of intimate images.
And so the non-consensual sharing of images, does that cover self-generated materials by children who have been groomed?
If the material has been produced and it's intimate material, and that material has been shared without consent, then yes, it would be captured under the legislation.
Is there a confusion there, or does there need to be a bit more clarity in differentiating self-generated material by children who have been groomed, who are being blackmailed, who are being forced to produce the material versus material that is intimate images that are being shared without consent?
I think, Chair, there may be an argument to potentially make that differentiation clearer, a criminal law, but I'll leave it, of course, to our colleagues in the AFP and the AGD. For us, the test is whether it's actually quite a simple test. Has the material been shared without the consent of the person depicted? Is it intimate material? If those answers are in the affirmative, then we can proceed with removal. And if we have a perpetrator in frame, then we can potentially issue a remedial notice as well. We actually have a very well-established ladder of regulatory interventions that we can apply regardless of how the material was produced, and that goes up to seeking injunctions from the federal court. So for us, it's really about being able to remove the material as quickly as we can and act as quickly as we can, and whether it's been produced consensually in the first place without any trick or manipulation or coercion or not isn't necessarily a factor that we take into consideration, except where our relationship with law enforcement is concerned. I think that's a really crucial point to make. Where we see evidence of grooming, we work very closely with the ACE to bring the facts to their attention so that we can determine whether or not it's the kind of issue that we should pass over to our colleagues in the AFP for further investigation.
Right. So what I'm hearing then is that there's potential to capture a broad range of perpetrators, people who are sharing images, young people who are sharing images without consent, that kind of what's called revenge porn, right through to self-generated cam by children who are being groomed. And then you make a determination around the origins of it, of whether of how to deal with it. Is that correct?
We perform an investigation, that's right. So if a person were to bring us information that showed that their material or material depicting them had been shared on the website without their consent, we're able to establish that lack of consent, which is obviously readily apparent if the person's under the age of 18. We will work directly with the platform to have that material removed. If we're unable to establish a perpetrator, if the person's not able to nominate someone who was in possession of the material, say, and shared it without their consent, then we'll focus on that first avenue. But if we're able to establish a perpetrator of image-based abuse, we'll consider what options are available to us to deal with their contravention of the fundamental prohibition against sharing image-based abuse material, which is expressed in the Act. But Chair, Deputy Chair, there may also be instances where we're able to neither establish a victim survivor because it's material that's been posted on a website that's been publicly reported to us, or a perpetrator. And in those cases, we'll deal with that material as Class 1 material under the online content scheme and work to issue a removal notice if it's not the kind of site that we can action through the in-hope relationship.
And does it matter if the victim is based in Australia or if they're an international victim?
In the image-based abuse scheme, as long as there's an anchor point for Australia, that enlivens our powers. So the perpetrator may be based here and the victim survivor may be based overseas, or it might be reversed. We might have a victim survivor here and the perpetrator's overseas. As long as we can establish that link with Australia, then we're able to enliven our powers. Okay, so it would capture people who are live streaming offences that are occurring in the Philippines, for example? The legislation is not really well suited to live streaming, only because it doesn't give the E-Safety Commissioner the power to intervene to deal with that live stream. And very often trying to understand the two ends of that conversation is very challenging. If that material, however, were then shared as a video file and shared on a website, that video was brought to our attention through the online content scheme, absolutely the kind of material that we could take action against through the Class 1 removal powers.
Great. I wanted to ask about two different kinds of platforms. The first one being online gaming chat rooms like Discord that are being utilised for targeting, identifying, grooming. And what role does the E-Safety Commission play there? And the second one being around the sharing of images on closed social media platforms, things like Snapchat, where you've got maybe a group of 10, 12 people who are sharing the images. But yeah, according to, and I don't mean to kind of verbalise what Snapchat said in their evidence at the AVM inquiry, but basically that, if somebody reports it from within that group, then they've become aware of it. But apart from that, they're not aware of it.
Mm. In relation to the first example, Deputy Chair, we don't see a huge amount of material that's relevant to either the image-based abuse scheme or the online content scheme be shared through Discord. That's not discounting the avenue that might be created through Discord service to establish grooming relationships with children, but that's more the domain of law enforcement. We're concerned with, so rather than the preparation phase, the actual production of the material or the sharing of material without consent. In the second case, the two platforms that are most heavily represented in our image-based abuse data are Snapchat and Instagram. And we have a productive relationship with both of the platforms, and we find that they do action our reports with haste and provide us with information that we're seeking to support our investigative activities. And so to the extent that Snapchat is responding to the exploitation of minors on the platform. Our experience has been that once we bring that to their attention, they do work swiftly to notify NCMEC, to take action against accounts and take other appropriate action according to their own terms of service.
So I can understand how that's done on Snapchat because you've got like a closed group and you share images in that closed group. But Instagram, is it through that sub-platform of Instagram Fan or whatever it's called, where you do only have a closed group?
Well, it's largely through Instagram messaging too. So messaging is a major component of all the traffic that is exchanged on Instagram.
Okay.
We see that messaging function.
Okay. And just if I could get your input on a thread that's kind of been coming out through the inquiry today around having a standalone suite of legislation that applies specifically to CAM and to online offending, in the same way that we have a fairly broad suite of specific standalone legislation to deal with terrorism and all the different aspects of terrorism, right from recruitment to fundraising. Would a standalone suite of legislation that deals with all aspects of offending here, right through from grooming to the sharing of images to the acquisition of an act to viewing an act to sharing of manuals to forming a group in order to share material, would a standalone suite of legislation assist the E-Commission in carrying out its functions with regard to this kind of material?
Chair, Deputy Chair, fortunately for us, we have the Online Safety Act commencing early next year, and that is a major step forward in creating a much better platform for us to utilise our powers across a whole range of services. We now have power to not just focus our attentions on Australia when it comes to hosting services that are providing access to child sexual exploitation material, but services that might have their origin overseas, that are being operated overseas. Our Class 1 removal powers extend beyond the borders of Australia, and that's the first time in the regulatory history of this particular harm that's been provided to the E-Safety Commissioner and prior to that the ACMA. So we are really looking forward to testing those powers as early as we can and exploring them through the course of the next year or two, and we expect that will really be quite a powerful augmentation of our role, because it really doesn't make any distinction between the different forms of particularly sexual-based harms that are directed towards children. The online content scheme actually doesn't define child sexual abuse or exploitation. It relies on quite a broad definition within the classification code, which refers to an offensive depiction of a child when they're not engaged in sexual activity. So it even provides us with the power to deal with material that depicts physical abuse of children. And as I said, the guidance that might be provided to offenders in terms of methodologies and ways of inveigling the trust of children, those kinds of guides are the sorts of material that are brought within scope as well. And of course, our image-based abuse scheme has proven to be particularly resilient and effective and robust. And so that doesn't see a huge change between the current situation and the new situation under the Online Safety Act, except for a shortening of removal times for platforms where we issue a removal notice. So we think that, to round off an answer to your question, we think that the full scope of powers that are provided to the Safety Commissioner under the Online Safety Act are an appropriate response to the breadth of issues that we've observed over the course of the last 5.5 years or so.
And you envisage that it will take 12 months to implement and see some outcomes from the Act?
Well, we are ready to implement now. So we've been spending the last 12 months doing just about nothing else other than getting our staff in place, getting our regulatory guidance in place, and we'll be looking to test those powers as early as we can. You'll see in the next several weeks, we'll have published all of our regulatory guidance to show how we're administering the schemes, and in particular, the committee may be interested in referring to our compliance and enforcement regulatory guidance, which sets out our approach to enforcing matters, the kinds of factors that we take into consideration when thinking about progressing matters for enforcement. And we'll have a very comprehensive explanation of the online content scheme as well, which sets out some additional factors. So I think if we were to have this conversation again in 12 months, we'd be able to have a much richer exchange in relation to how we're seeing those tools work to protect Australians and particularly younger children.
Chair, do I have time for one more question? Yeah. I wanted to ask you about the awareness and education piece. Because a lot of the research and the studies that we've seen today really make that differentiation between online offending and contact offending. To the point where we've had some witnesses today submitting recommendations or submitting evidence around kind of online interventions, early online interventions for people who are perpetrators. And another witness submitted a kind of a process of how someone goes about offending online, from accessing an identity to accessing material and how they do that. I wanted to ask you about an education and awareness piece that would go directly to online offending, really tackling this question of it being a victimless, or this defence that it's victimless, and whether there's a need for some awareness piece. An example would be like, somebody types something and a pop-up comes out going, you're about to commit an offence. These are the jail terms. There is a victim, those kinds of things. Have you seen anything like that? Is that something that you think would be valuable?
It's a really interesting question, Deputy Chair, because in 2019, we actually partnered with the University of Tasmania on this exact question about whether or not pop-up interventions were effective in discouraging people from accessing child sexual exploitation material. And the results of that research, which overall this area of research is in its early days, tended to suggest that deterrence messaging worked effectively to discourage people from taking that next step of clicking through into what they thought might be child sexual exploitation material, or at least some form of exploitation material. Obviously, the ethical concerns within that research project were quite sensitive, but the design demonstrated that was in fact a viable approach, particularly when it's backed by a message from a perceived authority like the Safety Commissioner, that there was harm associated with the consumption of child exploitation material, that there were penalties that applied in relation to accessing or sharing it. So that seems to have been demonstrated by this study and a couple of other studies. I think more broadly in relation to the comment that you make about online and offline offending, the thing that we really come to learn through being exposed to such a huge flood of content over many years is that overwhelmingly this crime occurs in private homes, and it is perpetrated by those who are close to the child, who are trusted by the child. We often think of child sexual exploitation in terms of remote exploitation via webcam and self-produced content and live streaming, but overwhelmingly the abuse of children happens within bedrooms, within bathrooms, and within parts of the family home. And so all of that offending starts with a physical, real-world offence against a child. And that's important to remember, I think, and one of the really important themes that's picked up in the recent Australian Centre to Counter Child Exploitation series, Stop the Stigma, which has real victims, real parents talking about their experience and working to start a conversation about the reality of sexual abuse in our community against children. I think that's a very important innovation in our conversation and our state of maturity in relation to this issue.
Is that research that you did with the University of Tasmania, is that available publicly, or are the findings available publicly?
It is, yes. There's a version that's published online, so we are very happy to take that on notice and share it with you.
That would be wonderful. Thank you so much. And were there any outcomes for that? Did you adopt any of the kind of the experimental pop-ups that you used in the research?
Well, not in any direct way yet. Certainly there was some avenues for further research to really understand why it was deterrence messaging as opposed to harm-based messaging that might be more effective in discouraging people from accessing content. But certainly it's a promising area of technical innovation that is worth exploring right across the board.
I'd be really keen to hear more. That's all from me. Thank you very much, gentlemen, for appearing today and for your wonderful contributions. And thank you, Chair.
Thank you, Deputy Chair. Look, you've covered the additional topics I wanted to as well. Pretty in sync after a long day of this. The other members of the committee have indicated that they don't have any further questions. So I don't, Deputy Chair, just confirming you're happy to let our witnesses go. All right. Thank you very much, gentlemen, and much appreciated. Thank you for all the work that the E-Safety Commission does under your guidance. Much appreciated.
Thank you, Chair. Thank you for having us. Bye-bye. Nice.
Thank you. And Sean, so just for the record, we will conclude today's proceedings. The committee will agree that answers to questions taken on notice of today's hearing should be returned by Thursday, the 13th of January, 2022. And there ends Hansard under broadcasting. Any issues from you, Sean, that you want to raise before we clock off?
No, all good, Chair.
All right. Thanks very much for your efforts today, mate. Thanks for sticking with us. Thank you, Deputy Chair. See you tomorrow. Thanks for those on the phone. Goodbye.